in YouTube as well. I wouldn't say I do a lot of YouTube streams, but someone asked for it, and it's a little bit easier to do the comments that way. So I'm gonna just see if we can actually get the stream up on the, oh, there it is. All right, so it looks like I am live on YouTube as well. I would like to get the actual link to that, so I'm going to grab that, and then I'm going to do a stream simultaneously on YouTube and on Twitter. So there you go. I figured it out all by myself, like an effective little towel. No one will say that Towel is not effective at what he does. It just takes a little bit of time because it is me behind a computer running an actual software program, not one of these sort of GUI server-based programs. Not that I disrespect that, but if you're going to do this kind of live streaming, you may as well treat it like television production and actually run a software, which, although it takes more steps to learn, is far more functional. That's how I can have all these complex backgrounds and things like that. All right, so we're on YouTube. So, oh, hi, Maui Swift. Good to see you. I'm able to see comments. The reason why I did the YouTube actually is Twitter's great, but the comments go off my screen really quickly, and I can't always see them. General rules with comments apply, though. Maui Swift, maybe if you want help with moderating, I can make you a mod. I would prefer people not use discrimination or really be vulgar. Don't make fun of people's medical conditions. But otherwise, you can ask your questions, and I'll be happy to answer them. Now, if you're wondering why are we live today, what are we talking about? Well, we're going to be talking about a number of motions. There's about 4 motions from the Commonwealth that just went up on the Karen Read trial docket. We're going to start with the most important one, because although if you've been following the issue that's discussed in the motion related to Karen Read's experts from ARCCA, who testified during the first trial under very strange circumstances, and then, of course, over the previous weeks and months, it has come out that Karen Read and her team had numerous undisclosed contacts and even paid ARCCA $23,925, which was initially sent by way of a retainer invoice in March of 2024 and then paid by the Read team on July 24th of 2024. And interestingly, that $23,925 is almost the exact same amount with $24,625 that was de-obligated from the federal contract when ARCCA was retained by the government. Now, this interestingly comes up by the government. By the way, ARCCA was retained in the context of the now closed federal investigation into John O'Keefe's death. Sure, Maui Swift, I'll be happy to make you a mod. All right, how do I do this? There you go. Congratulations. Congratulations on your promotion, Maui Swift. Now, by the way, I don't do a lot of YouTube streams, so if you are watching, if you like the YouTube format better than the Twitter format gets a lot of viewers, a little bit harder to keep track of comments. The YouTube format, I don't do it as often. If you want to share the stream there, that's great. Get more people asking questions there. I will answer your questions as I see them. Now, back to this point about ARCCA. So this motion about ARCCA is tied into the previously hidden contacts and payments between Read and ARCCA, and it's also tied into the fact that the de-obligated amount of ARCCA's initial DOJ contract for the now closed federal investigation into John O'Keefe's death was somewhere around $24,000. The contract was like $33,000. ARCCA got paid out about $9,000 from the DOJ. And then suddenly, according to statements by Karen Read's own lawyer, Robert Alessi, in court a few weeks back, Adam Deutsch, one of the line prosecutors at the DOJ, reaches out to Karen's team and says, will you pay this bill, which happens to be almost the exact same amount as the de-obligated federal funds for ARCCA's contract. Now, what I want to do here actually is I want to zoom in a little bit on this screen, so give me 1 second. If you are just joining us, I'm going to talk a little bit loud while I zoom in here because it's not the easiest thing to hold a microphone and then zoom in at the same time. If you're just tuning in, we're about to read through some of the motions. There's only 18 pages today. Thank God we don't have to do. I realized I talked for 5.5 hours the other day. And I think that's pushing the outer bounds of how long a human larynx can go for. But we're not going to talk for 5.5 hours today. Hopefully we'll keep this relatively short, 18 pages. I've now zoomed in, and I was giving you a little bit of context there. What we're looking here at is we're in the pretrial phase of the Karen Read trial, and there are motions in limine going up on the docket. Now, specifically what we're looking at in this context is There are a flurry of motions. First, there's an outstanding motion as to whether or not ARCCA is going to be allowed to testify, at all, because in the lead up to Karen's first trial, Karen violated Rule 14 related to reciprocal discovery, and the sanction for that was ARCCA had to go through a mid-trial voir dire. Now, the issue now is that because Karen had withheld the aforementioned contacts and payments with ARCCA from Judge Cannoni and state prosecutors under the veil of a then existing, although now confirmed as closed, federal investigation into John O'Keefe's death, that voir dire wasn't actually an effective sanction in the first go-round. So Hank Brennan has a motion, the special prosecutor in the Karen Read trial right now, to just remove ARCCA from Karen Read's witness list. Now, that itself has monumental implications, but that's not what this is about. What this is about is Karen Read's team submitted a motion of their own to basically Karen Read submitted two motions. One, to ban any mention that Read paid ARCCA. That's not going to fly. And then two, to be able to present to the jury that ARCCA was, quote, impartial and had no bias because the DOJ hired them. Now, what we're reading here is Hank Brennan's response to the second of those motions related to whether the jury should be told that ARCCA was impartial because it initially got paid by the federal government. Now, when we read through this motion, we are going to see a number of monumental implications, by the way. And we're also going to play an absolutely amazing video that my colleague and just venerated, wonderful human being found and sent, and I actually managed to download it and I have it ready to play, about the origin of this federal investigation and why did it start and was it pretextual and who knew it was pretextual. And but let's read Hank Brennan's words, because you can see them on the screen. You're probably reading them and you understand what I'm foreshadowing, but let's actually read them. Okay, so this is the Commonwealth's opposition to defendant's motion in limine to allow evidence of lack of bias. By the way, a little more context here. So there's a hearing in the Read trial tomorrow. I think there's another one this week. We are almost at trial, and so all these motions in limine, what you will watch happen at one of these marathon hearings, which is tomorrow, will start tomorrow, I think, is that I hope you have all these papers printed out, and you need to know what number they are in the docket, because you're not going to get motion titles when Judge Cannoni's making her rulings or taking things under further advisement. She's just going to say paper 499 granted, paper 501 denied, paper 502 granted, paper 503 under advisement, paper 504 I need to hear more information, paper 505 granted, 506 denied, 507 granted. I'm not kidding. And it will go like that for hours. So if you don't have a cross-referenced index, just as an advice for tomorrow, if you don't have a cross-referenced index of all the papers on the docket, all of their paper numbers, and then what I would recommend is actually, it's hard in PDF form, but I would print out if you can, although that's like 7,000 pages. I'm kidding, but it's a lot of pages. What you really need is all the documents by your side or very accessible, and you need to know their paper numbers. So you should have the docket printed out for tomorrow, and you should have all the documents, all the motions in limine. There's like 60 of them. We already went through the 126-page document. These are just more motions in limine. For tomorrow, make sure you have your papers in order, literally, if you want to follow this. Otherwise, it's going to be chaos. I don't care who you're watching, what stream you're watching. If you're just watching the court feed, none of it's going to make sense unless you have a cross-reference index of the docket with all the paper numbers, and then, because each document gets a paper number, and then also the documents themselves, because Judge Cannoni, sometimes you might get the title of the motion when the ruling's rendered, but most of the time you're only going to get the title of the motion during oral arguments on the motion, and we're just going to go through all of them. And then at the end, we're going to get rapid fire rulings on the things we can get rulings on. So if you don't have that ready and you're going to hear paper 508 denied, approved, it's going to just be chaos. But anyway, let's get to reading, because these motions in limine, for the wider context, are the last stage before we get to trial. So these are some of the last stage processes that we're going to be looking at. Now comes the Commonwealth in the above captioned matter, and respectfully opposes the defendant's motion in limine to allow evidence of lack of bias. Contrary to the defense's repeated representations to the court, the public, and the first jury, the employees of ARCCA were and are not impartial nor unbiased. The Commonwealth has a good faith belief that the defense instigated the now closed federal investigation and actively participated in providing selective information and materials to the U.S. Attorney's Office to attempt to propel and shape the federal investigation. First of all, a few important things to understand. One, attorneys speak in their first paragraphs. Two, Brennan is a genius, and if he's speaking in this way in his first paragraph, this is a bombshell motion. Three, that sentence alone has monumental implications, as I mentioned earlier. The Karen Read defense, reading between the lines here, this means that Hank Brennan has reason to believe that and probably evidence that the Karen Read defense in November of 2022 went and manipulated the powers that be under the old DOJ in Boston, Rachel Rollins and Josh Levy, who themselves had at least Rollins and the head of the public integrity section at the time, Dustin Chow, had long-standing grudges against Morrissey. Rollins because of political battles of will when Rollins was Suffolk DA related to youthful offenders, and Rollins sort of not really tough on crime stance for low-level offenses, which led to some of the other DAs criticizing Rollins, which led to Rollins reacting in particular against Morrissey. And then, of course, Dustin Chow had a alleged grudge because in 2015, Chow's wife was passed over for a promotion within the Norfolk District Attorney's Office, and as a result, Chow allegedly went around saying he was going to do whatever it took to burn down the Norfolk DA's reputation. So there's that, right? There's this. It's not just that Read was able to go spin a yarn. It was that you had a ready, willing, and able U.S. Attorney's Office at the time under Rachel Rollins and Josh Levy, who would have loved nothing more than for Read's yarn that she spun up about Morrissey and whatnot being true, as opposed to what actually happened, which was Karen drunkenly, in my opinion, backing up into John O'Keefe at 12:31 a.m. on January 29, 2022, and then leaving John to die before coming back to the scene at least once at 5:23 a.m., confirming John was dead, leaving again, going to collect 2 witnesses, coming back, and then getting sectioned by her own parents, and then taken to the hospital where her blood was drawn, and a retrograde BAC analysis indicated Karen's blood alcohol level at the time was between 0.013 and 0.29, therein leading to 3 different charges, including OUI manslaughter, second-degree malice murder by way of a reckless mens rea under the 3rd prong of that charge, and then leaving the scene of an accident causing serious injury or death. All of that is to say, there were a lot of political machinations and overlapping circles that aligned to allow Karen Read and Alan Jackson and David Yannetti, by the way, who used to work for Rachel Rollins when Rollins, he was on her transition team when Rollins became Suffolk DA. Oh, and another thing, why did Rachel Rollins, the then U.S. attorney, when Karen Read managed to get this probe spun up, why did she get forced out of her position according to a DOJ Office of the Inspector General report released in May of 2023? Well, Rollins allegedly, in fact confirmed according to the DOJ OIG, used her position to launch a pretextual federal probe into Kevin Hayden, who beat Rollins' ally Ricardo Arroyo in the Suffolk County DA primary after Rollins left the position to take the position of U.S. attorney. She launched that pretextual federal probe, recused herself from it, and then leaked the recusal to the Globe and the Herald to try to smear Hayden. And you want to know what's even more interesting, because we're going to play a clip from Turtle Boy in a second, and I want to add a little more context before we play this clip. It's Turtle Boy a while back talking about who started the federal probe and how. I want folks to remember, look into, I think it was the 2020 Senate race between Joe Kennedy Jr. and Ed Markey, and start asking questions about why was Turtle Boy messaging Rachel Rollins, of all people, about that Senate race, and having Rayla Campbell, a Republican spoiler candidate, go to Joe Kennedy Jr. events to make that Senate race fait accompli for Ed Markey. And you might say, Grant, what? But no, it is actually true. Turtle Boy and Rachel Rollins communicated directly about that 2020 race. And you might say, but Grant, Rachel Rollins is a Democrat. Turtle Boy's clearly leans pretty right, okay? Rayla Campbell is a declared Republican. Why would Rachel Rollins be working with Turtle Boy in 2020 to send Rayla Campbell to Joe Kennedy Jr. campaign events to help Ed Markey? Well, why would Rachel Rollins get appointed to U.S. Attorney by the Biden White House? Could it be perhaps that those two things are connected? And could it be the reason that those two things are connected is because it was actually in the interest, at least in 2020, of the Biden White House to make sure that Joe Kennedy Jr. did not win that Senate race? Because otherwise Joe Kennedy Jr. would have gone from the House of Reps to JFK's old Senate seat and lined up a presidential primary challenge against Biden in 2024. Could it be that helping Markey win that race and doing it in the way that Rollins did resulted in Rollins getting a thank you by way of being appointed to the U.S. Attorney's Office, despite the fact that she got forced out like a year and a half later for launching pretextual federal probes? Folks, you got to see how all of this ties together. And now I want to play this clip, and I want to send a special shout out to the person who found it, because they are a boss, and bosses like that should get special shout outs. I would wave to them, but they need to focus on driving. All right, here we go. Hold on, I'm going to play this clip for you now. Let me just bring it up on the screen.
You think went to the feds. Think.
All right, hold on.
We've got connections like who would go to the feds. Think.
I got to start.
Not going to say anything else. It's pretty obvious. No, it wasn't Higgins who went. It was not Higgins who went to the feds. I'm telling you, Higgins isn't going to go there.
So let's take a listen to this clip of Turtle Boy. It was a while back. I think talking about who started the federal investigation.
Okay, so this stuff about who went to the feds. It wasn't Wanless who went to the feds, guys. Think about who went to the feds. You think went to the feds. Think. We've got connections like who would go to the feds. Think. Not going to say anything else. It's pretty obvious. No, it wasn't Higgins who went. It was not Higgins who went to the feds. I'm telling you, Higgins isn't going to go there. And you guys are missing the most obvious fucking thing. I mean, think about it. Who's going to go to the feds and say, "Can you investigate the investigators?" Who's going to do that? Think about it. I can't believe this has to be spelled out. It's not Brian Higgins. Brian Higgins is going to go, "Yeah, investigate me, please." They got away with it. Why would he go to the feds? It makes no sense. Think about it. Think. I'm not going to say it. I see one person got it at least. The obvious answer, but okay.
Now, what's weird is in the comments, people were like, "Was it Turtle Boy?" But I think what he's saying is in the comments, someone said it was Karen. Because it was Karen and her team, in my opinion, and Yannetti, who started this pretextual federal probe in the fall of 2022. Now, there's this even weirder, we're going to keep reading this motion, but just to lay out all the facts, because I've looked into this as much as I can, and there's this weirder dynamic, right? Where in April of 2023, right as Karen's really getting her third-party culprit nonsense theory going, Aidan Kearney, from what I understand, was facing some kind of problem or issue related to allegations that he, unrelated to the Reed trial, just unrelated to everything about this case, had something in Rhode Island. A woman had allegedly been wiretapped, was complaining to the Holden police. Kearney had used a Rhode Island number allegedly on this call, but was in Massachusetts when the alleged wiretapping had took place, and there was an investigation. So Karen says to Aidan, through an intermediary named Natalie, right after April 20th of 2023, Aidan should talk to Alan. You always get a shot in the arm when you talk to Alan about your problems. That's what Karen said to Aidan through Natalie. And my mind really does wonder if what happened was Alan Jackson and David Yannetti, it wasn't just that they were working with the DOJ, it was that they were helping them run sources. And so they brought the DOJ at Aidan Kearney and said, listen, this guy's got some issues going on with this wiretapping thing. Again, entirely unrelated to the Reed case. Can you help him out? Now, here's why I say this. I have very, very good reason to believe that an FBI agent named Samuel Weiner from the Worcester field office, which is a real name, reached out regarding this case, that case I mentioned that the Holden police were looking into way back in the spring of 2023, reached out to people about it. And you got to wonder why that serendipitous timing. April, May 2023, right as Karen and Alan and David get introduced to Aidan Kearney, and right as Aidan saying he has this issue and Karen saying talk to Alan, for a few months there in the summer of 2023, did Alan hook Aidan Kearney up with the FBI in some way? It really does line up. But then what's really interesting is, did things eventually take a turn in August of 2023 when the federal probe, as we know, started looking into the death of Sandra Birchmore and the potential cover-up of her murder involving the very same MSP unit, state police unit, attached to the Norfolk DA. Is it possible that sort of Aiden fell out of favor with the feds, helped them a lot during that summer 2023 federal grand jury, but was that really just pretextual cover to look into general police misconduct? Because remember, that old DOJ under Rollins and Levy, they were hitting the MSP and all cops really hard. It was kind of like an anti-cop ethos under Rollins. They were looking into like the Troop F overtime scandal. There were at least like 3 or 4 police misconduct cases in a row leading up to when this whole thing with Karen and John's death went down. So interestingly, we know from Josh Levy's public statements at the indictment of Matthew Farwell in August of 2024 that the probe of Sandra's death and cover-up started in August of 2023. Levy said as much publicly at the remarks. I was there. He said it in front of me. I was 3 feet away. So, therefore, did the federal probe into that MSP unit shift circa the fall of 2023? And as a result, was Aiden Kearney no longer useful? And is that why when Kearney picked up the witness intimidation charges in the fall of 2023 and then the further charges in December of 2023, was he not as useful? And there's some things you have to really think about. Like, why was Aiden Kearney asking people to talk to FBI agent Leah Ferreira? Like, and not just that, but why, according to reports, was Kearney unable to get Leah Ferreira's cell phone number on the weekend of December 23rd, 2023, before his bail was revoked? Like, if you're connected with the FBI, like one of the first things I'm speaking very generally, one of the first things you're going to get is like either a desk number or a cell phone number, probably. So, and that's for like non-sources. So Kearney, in my opinion, couldn't have been any kind of source or anything like that by December of 2023. And you even had Tim Bradle, Aiden Kearney's lawyer, at a court appearance in December of 2023 saying he had tried to call the DOJ and the FBI that morning before the bail was revoked. And so it's making me wonder, did Kearney have some use at some point, and was it by way of Jackson? That's what's really under the surface here. That I think as much as Karen Reed was talking to Josh Levy and the powers that be at the DOJ, I think for like a 3-month window there, they were really talking to Aiden. And they may have even given him voucher payments. I've heard, rumors swirling. Who knows where that's going to go? But we have a real black mass on our hands here, folks. And Hank Brennan spelled it out in a sentence. Look at me pointing to the text. In a sentence. Now, obviously, if you are not well versed in this case, then everything I just said and all those overlapping concentric recursive historical social circles are not necessarily going to make sense. But if you can follow that, then you see what's lying beneath Brennan's sentence there is you could write a whole book. And by God, I may actually just do, I think I am going to do that. You could write a whole book about that sentence. And I'll tell you what, every single person out there who spent time trying to deny the FBI involvement in this and the Kearney interplay and the political dynamics, they had their own motives, I think, because there was serious misconduct that was occurring, in my opinion, related to Sandra Birchmore's murder and the manipulation of Lindsay Gattani's cell phone extraction while it was in the possession of the MSP unit in question to remove specifically text messages from Kate Peter and Brian Tully before 15 years of that extraction was leaked to Aiden Kearney's lawyer by Tully himself. So I think there's a lot of motive for people to be like, no, the feds aren't looking anything. There's nothing wrong. Everyone's above board here. All these people are wonderful. Jen McCabe and Tully don't talk, and Kate and Tully don't talk. It's bullshit. It's fucking bullshit. And I hope Hank Brennan is like, the interests of justice are more important than all of you fuckers and your private investigation firms and your bullshit tactics. And although I've talked about this before, I don't care if Karen went low by bringing on Kearney. It was wrong for this fucking PI firm or whatever the fuck to bring on Kate Peter and for these weaponized polemical tactics to come to create and engender this hostile toxic, nonsensical atmosphere around this case that took months to fucking break down, and it was entirely unnecessary. And yes, I get it. This was a fucking proxy battle, and I think Hank Brennan gets it too. It was the Norfolk DA and the DOJ fighting it out, and the DOJ had Karen and a Turtle Boy, and the Norfolk DA felt, cornered, and all the witnesses felt cornered, so they went to Kate fucking Peter. This militant, in my opinion, like, very strange, like, moves in online, kind of like noble as it may be, but like predator hunter circles, has all these like weird friends, like, who are like toe the line between like good and evil, like, constantly, and are willing to justify, like, you work in an ends justify the means arena. I get it. That's what Turtle Boy does too, apparently. So you must deploy those kind of tactics. But it's all driving back to this nonsensical, pretextual federal investigation that itself was a byproduct of this history of tension between the Norfolk DA and the U.S. Attorney's Office in Boston, in particular, under Rachel Rollins, and then also Dustin Chow. And folks got to realize, look up the public integrity section. When you have the very unit focused on public corruption with someone with a grudge in it, this whole system can get weaponized. And how do you think it gets weaponized? The currency of this kind of political power is, oh, you might be investigated. Oh, I hope folks don't find out you might be investigated. If you think for 1 second that doesn't happen, you're kidding yourself. But that's the package here. That's just the introduction. We haven't even got really into the details, and we will see the details get even more explosive, but that's the intro. Let me take a second to see if there's any comments. Oh, there are some comments. Oh, this is wonderful. I can see that Maui Swift is doing some moderating. Hello, Hillbilly Nitro USA. I'm glad you're enjoying your Canadian bacon. Let's see. People think a Fed-protected asset has to exchange brown envelopes of cash and meet in the smoky back alleys. Murder by Maestro. Have you ever looked up the story of Buffalo Jim and Steve Miller? There's an excellent documentary that you should watch about the Crazy Horse 2 strip club. Buffalo Jim was actually tangentially associated with the WWF in the early 2000s, back when I used to watch a lot of Attitude Era wrestling. But that story will tell you all you need to know. Go ahead and search my feed by advanced search and just run a query on Steve Miller, and you will get the post. This is the kind of op the FBI runs. It's in their playbook. Steve Miller says it. Sign the asset to a 7-year NDA, use like a journalist who has like somewhat medium attention, use search engine optimization to make their blogs like the primary source of information about whatever it is that's going on, and then simultaneously use put very specific references to their contact information in the articles and drive tips through them. So use the coverage as kind of like a honeypot, and then drive tips about your target through the public attention. I think the whole Free Karen Read movement was a fucking honeypot. And if you don't believe me, I mean, go look into that story. Okay, let's see. I'm reading through the comments now. Someone said Brennan is lifting the curtain big time. I agree. Someone said Grant is more book smart than me, so I think the same, but I think it in idiot language. No, you're very smart, Murder by Maestro, and it's not that I'm book smart and you're an idiot. It's that I'm book smart and you think like a computer. So you translate hexadecimal, like you think in base 2 and I think in words. And your ability to think in base 2 is far more valuable than my ability to think in words. It's just people don't appreciate it as much. So don't sell yourself short, my friend. I think Kate and Aiden didn't need to be hired or even enabled to create what we see. Simply they were put in a position out of reach or complicated due to the FBI probe. Grant, am I wrong? No, Kate worked for Marty Kraft, who's a PI that's very tied in and potentially investigated Karen Read. It was a job. For sure it was a job. And then I think the whole PR component of it and Kate's relationship with Jen McCabe, I think that also, listen, you can get compensation directly. Like I saw Kate get an envelope with cash, hundreds of dollars in a Chick-fil-A parking lot. And then I have a text message where the person's relative who sent the money admitted to sending it to Kate. He was like dropped off by an intermediary or something. Someone's sister dropped it off to Kate in the parking lot. But you can also get, other forms of indirect compensation, like you can get things paid for, or you can like think in the future and say, all right, we'll do this work together, and like we'll do do speaking tours, or like book deals, or we'll direct like people to a website where we like sell stuff, and then we, you know what I mean, like that's what I think might have happened. And then Turtle Boy, I don't even want to get into that. There's no doubt in my mind that this was a whole sort of operation. I don't know how exactly it worked. I bet that the donations going to Karen, who knows what percentage of them would actually go to Karen if they were dono splits. Did you have to get permission to run a stream to do donations for Karen? And then if you were in some like top tier, could you take a cut of it? I'm just thinking out loud as to how that kind of thing could have looked. I agree in binary. All right, sorry for the distraction on the questions. I just wanted to make sure I got through the YouTube questions, because I'm very intent on saying if you have questions, you want to participate, I will engage with you. I don't require donations, super chats, or whatever. If you have an opinion, as long as it's not vulgar, derogatory, or insulting someone's illness, I'm generally going to engage, especially if you think in binary. All right, let's keep reading, because as much as it's fun for me to give all that context. And by the way, Hank Brennan, in my opinion, has all this context in his mind. Don't think for one second that, although this is it's surface level with bombshells, although this is a surface level analysis compared to everything I just said, don't doubt for one second that Hank Brennan could not stand up there if he really wanted to. He would never. And explicate that history that I just told you with all those overlapping concentric social circles. Maybe he'd leave out the Kate Peter stuff. But the point is, he could tell you the exact same story, because that's the underlying tension that Hank Brennan's talking about, shaping and misleading people. And he's giving some good cover to the U.S. Attorney's Office here. And I, just as a commentary, I think it's a great way to do it, because it lets the U.S. Attorney's Office say, listen, that was the past. You got a very virulent Republican administration who'd probably love nothing more than to throw Rachel Rollins and Josh Levy onto the proverbial congressional fire. So Brennan is being smart in the way he's presenting this. Let's see, where's that? Okay. First, the extent of the murky relationship between the defense team and the past administration of the United States Attorney's Office is still unknown. Genius. Okay, so I didn't even catch this the first time around. Do you see how he does it? Brennan immediately says, look, we're talking about the prior administration here, and he's almost belying that there's something more there, right? And that it's a foreshadow. And Brennan says here in footnote 1, numerous TUI requests have... Now, a TUI request, by the way, let's contextualize this, because Brennan will just drop this term, but it doesn't mean anything unless you know what he's talking about. So the case is U.S. ex rel TUI v. Reagan from 1985, and it's interpolated in the U.S. code. I think it's 126 CFR 000, and then that itself is explained in Section 25 of the DOJ Operations and Sections Manual. But basically, when there's a federal investigation and you have a concurrent state criminal trial, and you want to get information from the federal government, whether you're the prosecutor or the defendant in the state criminal trial, you have to do like a public informations request, a FOIA, a Freedom of Information Act request, but on steroids. There's a lot more exceptions, and the government's not very forthcoming. But we're going to find out that this TUI process comes up again in this document, so understanding what it is important. So when Hank Brennan's saying TUI request, he's saying he's going to the DOJ, and he's obviously started this process in the fall of 2024, probably earlier, when there was the old DOJ administration under Biden, Levy, Rollins, although Rollins was gone by then. But now we're talking about the numerous TUI requests that also started to go in with the new DOJ administration, and that plays a big role a little bit later in this motion. Numerous TUI requests have not produced sufficient relevant and material information needed to identify the extent of the relationship between the defense and the U.S. Attorney's Office, and what, if any, impact the relationship and source of materials may have had upon the scope of ARCCA's directive and efforts. Now, of course, because TUI requests, as Hank Brennan have said before, are a notoriously dark, just black hole. They're designed to not give up a lot of information, but that's why it's so fascinating, folks, that when we get to a little bit like one page from now in this motion, We're going to find out that something came out of a TUI request that normally you would never expect to see. So let's continue. Okay. So we only got through the first sentence. To this day, it is unclear how the relationship may have shaped or impacted ARCCA's efforts. The actual directive to ARCCA made by the past administration of the U.S. Attorney's Office and any shaping of ARCCA's efforts are not known. Exactly. No, the framing here is great, though. It was the last administration. Wow, so Biden, Karen Read really needed Biden to win that election, and that was not happening. I don't even think Karen Read's a Democrat. Pretty sure they're all Republicans. Must be such a weird situation for them to be in. Having allied with I'm not gonna lie, like Rachel Rollins, if I were to be very direct, I would say she literally probably would say all cops are bastards. And she was a Fed. She was the top law enforcement officer in the federal jurisdiction of Massachusetts. All right. By the way, I don't agree with that. By that mentality that all cops are bastards. I think that's a terrible fucking mentality that disgraces and insults public service. It would be like saying court officers are bastards or something. No one would ever say that. But with cops, it's easier because there are, I guess, far more obvious, even if they're few and far between, bad apples. And so the whole profession gets a very negative reputation, which then causes this reactionary circle where cops become alienated and then there's more bad behavior. But police officers, it's like firefighters. It is a very noble profession at its core. And I will never understand this mentality of the people who literally work 24 hours a day in shifts to keep people safe are all bad. That is the stupidest fucking nonsensical position. And this is coming from someone who helped reform drug laws in Massachusetts, who doesn't like the drug war, etc. To say that individual cops, every single one, are just terrible people is just such a fundamental misunderstanding of how the justice system works. I can't even engage with that mindset. And I worry that that was the fucking mindset under the DOJ when Rollins was U.S. Attorney in Boston. Which, that's just crazy land. And I'm basically a liberal. I would call myself more like a Thomas Jefferson style, like nonpartisan Democratic Republican, but I'm basically a moderate-leaning liberal. And I think that's crazy, that was potentially what was underlying this probe, coupled with the hatred towards Morrissey. It has been established that throughout the course of the federal investigation, the defense communicated with the U.S. Attorney's Office and provided material selected by the defense without any input by the Commonwealth, including related claims and information that advanced the defense's theory of the case. This came out in the lead up to the first trial. Adam Lally did a yeoman's job of arguing this point. He was able to do it too when the TUI response, the 3,000 pages or something, in the lead up to the first trial came out. Prosecutor Lally was like, we didn't get any input on this. This is crazy. How did this happen? And you could see him saying it. The way the federal protective order worked is the parties could only mention the documents in oral argument. So you'd hear Lally stand up at oral argument and just be incredulous at what had happened. But I don't think so. Brennan used to be in the federal world. I think he was might have been a prosecutor, might have also done federal defense work. I think he was court-appointed counsel in very high-profile cases like the Bolger case, etc. So if you're court-appointed counsel in a murder case, especially that kind of murder case or something, organized crime, you are the top press. You have the respect of the federal judges themselves. So Adam Lally may have been what the fuck is this? Hank Brennan's going to be oh, I see exactly what the fuck this is. What happened? And that's, I think, what we're seeing here. Unlike Adam Lally, who was how did this happen? This is crazy. The situation with only the defense providing information and the U.S. Attorney's Office and all of this, it's like a black hole if you don't know the system. Whereas I think Hank Brennan knew the system and was oh, this was clear, clear pretextual playbook. This is how that kind of op gets run. Let's expose it. That's impressive. A specific accounting of all material provided to the ARCCA witnesses by the U.S. Attorney's Office are indeterminate. So Brennan's making a lot of points at once here. The other point he's layering in here, he's crescendoing up to saying, by the way, we don't even know the full extent of the contacts between ARCCA and the U.S. Attorney. So forget about ARCCA forget about telling the jury that ARCCA was retained by the federal government. The ARCCA shouldn't even be able to testify. We don't even have enough information to determine what the nature of ARCCA's involvement in this whole process was, and whether or not Read's attorneys and the feds were feeding ARCCA intentionally out of context information, which, as we know from trial testimony and as we're going to read in this motion, the ARCCA witnesses would get crossed and they'd be asked questions like, so were you provided this evidence, access to the car or John's DNA evidence? And the ARCCA witnesses would be like, no, what are you talking about, Lally? And Lally would be like, well, did you know that we had this evidence? And if the defense or anyone or you had just asked, we would have given it to you. And he was like, oh, no, we didn't know that. The ARCCA witness. It was a very awkward moment. And it just goes to show, I think, and some of the newly undiscovered contacts and payments between ARCCA perhaps go to show that it wasn't that ARCCA was like clueless. It was that they were potentially in on it. Now, by the way, one more piece of context here. The federal protective order that exists related to the now confirmed as closed federal investigation into John O'Keefe's death, a few important things. One, it keeps going, the federal protective order, regardless as to the investigation closing. And two, the other thing is it doesn't just cover documents produced in the federal case. It covers Read's defense and the prosecution's ability to interact with ARCCA. Now, guess who enforces those federal protective orders? Technically, the federal court, but guess who actually has to bring it to the attention of the court? The U.S. Attorney's Office. So how concerning would it be if Read and ARCCA violated a federal protective order about how much contact they were allowed to have during and in the lead up to Read's state criminal trial, and the U.S. Attorney just gave it a wink and a nod? That's what and we don't even see that in this motion from Hank Brennan, but that right there, that sentence of all the accounting of all the material between ARCCA and the USAO being indeterminate hints at something much deeper. And as you know, as much as attorneys love to be logical and debate, they also like to be very circumspect with how they talk in court, in their motions. It drips every word they write or say, unless you're like a really bad lawyer, just drips with what can you find beneath or between these lines. And that's what a good legal motion should be. It shouldn't slap you in the face with these ludicrous PR theories. It should be this exercise in it. The text only gives to you as much as you bring to it. So that is the beauty of a good court motion. Not every court, in fact, most court motions are not speaking motions where you're saying something to the public but pretending to write a court motion. Most court motions are written for a judge, the audience, who knows what you're talking about. And so if you're saying anything between the lines, it should be for the judge, which is what Hank Brennan's doing. Now, yes, it reduces some of the impact, because if Hank Brennan just came out and wrote 30 pages, which he could, about everything I just said, yes, it would really make the point, and yes, it's protected and he can do it in the motion, but it's pointless. What you really do here is win the argument in front of the judge, which is, of course, the jury is not going to be told that ARCCA was somehow non-biased because they were initially retained by the feds. To do that would, first of all, require showing the full context of this nonsensical pretextual federal probe, but also it doesn't even make sense because ARCCA won't even be testifying if the law is upheld, because so much reciprocal discovery was violated that to even have them get up on the stand is a manifestation of undisclosed bias of such serious degree that it just disgraces and slaps the face of the justice system. That's basically what Brennan ends up arguing in his motion. All right, if I keep going on tangents, we're not going to get through this motion. We're going to do it. Much of the inculpatory, that means showing that Read is guilty. No, exculpatory? Yeah, inculpatory. Much of the so much of the materials showing that Read is guilty do not seem to have been provided to the ARCCA witnesses before they conducted their testing and presented their report. Now we got to go down to footnote 2. Let's take a meander. In its report, ARCCA witnesses did not appear to consider Mr. O'Keefe's DNA on the defendant's Lexus broken taillight casing, taillight shards from the defendant's broken taillight found in Mr. O'Keefe's clothing, tech stream data, and numerous statements and admissions by the defendant to various sources. Hank Brennan says it better than I could, but I knew where he was going with that one. ARCCA testified to information and materials that were not noticed in their report as materials reviewed. Oh, that's interesting, Mr. Brennan. The uncertainty and lack of transparency is frustrated by the defense's continuous promotion mischaracterizing the ARCCA report and findings. As part of a closed federal investigation, the U.S. Attorney's Office contracted with ARCCA LLC. On February 12, 2024, ARCCA generated a 13-page report of 4 specific findings. Those findings were not, as the defense claims, unequivocal evidence that the victim was not struck by a vehicle. Rather, the ARCCA findings were narrowly tailored to whether the ARCCA witnesses believed the injuries to Mr. O'Keefe produced damage as observed in photographs to the Lexus. In fact, the defendant's expert, Dr. Rentschler, testified that and acknowledged that if there is a sideswipe impact with a pedestrian and a vehicle, there's going to be very little damage to the pedestrian. So a sideswipe, by its very nature, involves minimal impact, minimal forces, minimal velocities, which, contrary to the defense's claims, advances the Commonwealth's theory of the case. Exactly. Because you could have damage to the Lexus from a side swipe, which doesn't necessarily mean that the damage to John's body would be grotesque or beyond what was visible in the photographs, coupled with the damage to John's head, which probably wasn't caused by the impact with the car, but instead by John falling to the ground. And then I think we come to find out in another motion that it's actually very common for the most serious part of that kind of 24.5 mile an hour collision, the most serious potential injuries to the pedestrian to be upon the fall to the ground. And that makes it all the more sad because if Karen had just stopped and gotten out, there would have been a far higher chance of survival because one of the contributing factors in John's death was a blackening of his pancreas indicating hypothermia, which means maybe John was knocked out from falling to the ground after being sideswiped by Karen's Lexus. But had he not been left there for 5 hours and had aid been rendered, he might have recovered. And if he had this brain bleed, which was caused as a result of his skull hitting the ground, even if that got early intervention, prognosis for recovery probably would have been higher. I'm not a doctor. I'm not a lawyer. I'm a towel. And this is just my lay opinion. But I really do think that's what makes this whole situation so sad. It's that I think that John being left there by Karen for so long, with Karen saying nothing and doing nothing and alerting no one, is what fundamentally caused John's death. And that's why I think she has, even if she gets a plea, she's going to have to go to jail for a substantial amount of time, 4 to 6 years or something, because it was but for Karen's actions, John would be alive. Not just the car crash, but the leaving, the not rendering aid, not helping, not telling anyone. She could have saved him, and her lack of intervention caused his death. That's why she really has to, in my opinion, show not just allocution and contrition and remorse, but actually go to prison for a substantial amount of time. And obviously 4 to 6 years is not nearly enough, but it's substantial, especially for someone from Karen's position. All right, so we're going to continue. Let me see if there are any questions. We're on page 2 of this motion. Oh, sorry about that. All right, what do we got? Do we got any questions? Soft on crime Rollins. Also, ARCCA was given very specific and limited information. Why would you limit information? Because you want a specific conclusion. Absolutely right, D. How the heck did ARCCA explain Karen's taillight all through the snow surrounding John's body? I don't even think they were told about it. I'm feeling my brain grow listening to Grant, but feel it shrinking because rolling a reefer. Well, I'm smoking a blunt, so with tobacco. How did ARCCA, well, I'm actually a medical patient, so how did ARCCA explain fragments of taillight embedded in John's clothes? I don't think they were told about that until cross. How did ARCCA explain John's hair on the back of Karen's taillight? Just as Prosecutor Brennan said, I don't think they were told about that either. CTE is a brain issue. No, because she'd be paroled before the 4 to 6 is up. Yeah, but I wonder if they could do. You might be able to do some kind of. Yeah, maybe you can't forego parole. Massachusetts is a very lenient state, so. ARCCA work on accident reconstruction in less than 5% of their income. They're a lobbying firm with patents, not recon. Yeah, I noticed they do a lot of lobbying for patents and products. You pointed that out, Murdered by Maestro. My grandfather's, this is Dee's comment, my grandfather was killed by a car while crossing the street. Both of his shoes came off. I'm sorry to hear that happened, Dee, but thank you for sharing as it's relevant to the topic. ARCCA is a lobbying firm, ? I need to check their website. Yeah, you should. And don't just check their website. If Murder by Maestro can link it, he did an amazing analysis of ARCCA's federal contracts, and you'll find that they have this weird sort of patent system. They work on, like, I think it's like, what is it? Seats, some kind of seats for airplanes or some high level, like, military application technology. And then what they do is they lobby to get contracts awarded in that area so that it's like a recursive thing. Like, they develop the technology and they lobby the government to give them contracts to pay for it. But it's like, I forget exactly what it is. It's a very weird form of technological work they do. It's like very precise military technology having to do with, like, impact cushioning and things like that. But they do a wide array of work. They're a big firm. They employ a lot of people, and I think they probably internally and externally took some heat because of whatever this division, this accident reconstruction division, was doing with the Read case. But okay, back to the motion, because that's we're talking ARCCA, but we're also talking motions. And anyone who wants to ask questions can continue to do so. Just recognize I have to then take some time to read them. Second, there is no adequate assurance that the ARCCA witnesses lack bias. The past opportunity to voir dire the ARCCA witnesses did not mitigate the lack of transparency about the ARCCA defense relationship. The defense did not inform the Commonwealth about its substantive relationship with ARCCA until February 13th, 2025. Now, before we read the next sentence, I want folks to understand this. ARCCA and the defense, no matter what contacts they have, federal protective order or otherwise, in particular when it comes to things like compensation and things, potential compensation, expected compensation, you can get paid and things like that. But if you read Rule 14, the discovery rules, it might be Rule 48, but I think it's Rule 14. If you read the reciprocal discovery rules under the Massachusetts Rules of Criminal Procedure or Evidence or whatever it is, you will see that there are specific things, if you're the defense and you want to call a witness, you have to turn over. Your contacts, the way you're communicating, especially about substantive trial testimony, and you have an ongoing obligation to turn this over. We're going to find out that at least between March 2024 and July of 2024, perhaps later, there were payments, contacts, and more that the Read defense not only did not turn over in the lead up and during the first trial, including during the voir dire that was a sanction during the first trial for violating Rule 14 to begin with, to the state or Judge Cannone until February 13, 2025. And you might say, Grant, why? Why would they all of a sudden do it? Well, folks, what happened on January 20th, 2025, as Hank Brennan's about to say? A new U.S. attorney came in to office. And all of a sudden, the brick wall that Hank Brennan had ran into for months and months and months and months and months, the floodgates open. And Leah Foley, channeling her inner Lawrence Sarhart from the days of Towell's favorite book as a 10-year-old for some reason, Black Mass. I don't know what to tell you. Leah Foley steps onto the scene and says, we find out, I initially thought it was maybe Leah Foley or her office, U.S. Attorney Foley did this too. I thought initially it was the U.S. Attorney's office after President Trump came into office. You know, Levy goes out, Rollins' crew is gone. The new U.S. Attorney comes in and says to Jackson and Yannetti, the game is up. I don't know what you are all doing. Turn those contacts over. Do it yourself. I thought it was that kind of burn notice. No, look what Hank Brennan says in this next sentence. Notably, the defense disclosures came one day after the new administration at the U.S. Attorney's Office produced, in response to the Commonwealth's TUI request, materials that had included correspondence between it and the defense. Now tell me, folks, didn't we just read a little sentence earlier saying that numerous TUI requests from the Commonwealth, including Mr. Brennan himself, had gone unanswered? And do you not remember back to oral arguments a few weeks ago where Mr. Brennan was detailing how those TUI requests he sent were in depth? And what Mr. Brennan means by that is it's kind of like writing a good FOIA or a good public records request. You're querying a search engine that is hostile to you, and you must be precise. You must list out your search terms in a way that forces them to produce responsive documents, and then even then it's a sentient search engine that can invoke exceptions to the disclosure rules to prevent the very things that you might have hit on with your search from being included in the documents. Now, Hank Brennan detailed how he got this whole unresponsive package from the old DOJ sometime in December 2024 or January 2025. But then all of a sudden, new DOJ administration comes in, and then on January 30th, in response to the Commonwealth TUI request, which previously had yielded nothing, materials that included correspondence between it and the defense. Before February 13, 2025, the Commonwealth was wholly unaware of the defense's relationship with ARCCA, including proposed retainer agreements, intention to compensate, and collaboration relative to questions and answers at trial. Let's read that again. Before February 13, 2025, the Commonwealth was wholly unaware of the defense's relationship with ARCCA, including proposed retainer agreements, intention to compensate, and collaboration relative to questions and answers at trial. That's right. The defense and ARCCA were literally collaborating on how to answer questions at trial. I completely forgot about that part. Oh, hold on one second. I got multiple things going on here. A lot of people have things to say, apparently. But that's all right. I consider these insights very important. Oh, someone said, oh my God. All right, well, you're going to have to tell me what oh my God means, because otherwise I don't know what you're saying. All right, hold on. I have my eye on multiple developments right now, folks. If it is prescient and pertinent to our discussions, I will relay it. But this has me thrown off in the middle of my stream because there's so many things going on. Oh, that's right. I was talking about how the ARCCA witnesses, it wasn't just that they were being paid by the defense and these material contacts were being withheld from the state and Judge Cannoni. It's that they were planning the testimony. ARCCA was almost like a consultant for the defense, according to what Hank Brennan has produced previously. Hold on. What happened? All right. I could just say what happened over stream as opposed to responding, but that's, I can do both. Now I'm very, very interested. And then I had mentioned this earlier. The past opportunity to voir dire the ARCCA witnesses did not mitigate the lack of transparency about the ARCCA defense relationship. The defense did not inform the Commonwealth about its substantive relationship with ARCCA until February 13, 2025. Oh, we already read this part. Wow, this better be very big because I just got thrown off reading a motion and that never happens. So we just talked about how the Commonwealth before February 13, 2025 was not aware of any of these contacts. Rather, the questions posited by the defense during voir dire testimony and trial testimony created impressions that were clearly not consistent with the actual relationship between the parties. It was basically like Alan Jackson tried to induce the impression that ARCCA was independent when they were not. The voir dire was necessarily insufficient and fruitless. Has something major happened? All right, hold on. I'm gonna go over to my Twitter here and let's see if something major has happened. Normally, if a big motion goes up, Dee or Dagnabbit has it. So let's go to Dee page. No new motions yet. Okay, that's all right. I'm keeping my eye on things. All right. So Alan Jackson induced questions from induced answers from ARCCA that definitely tried to imply that they were not biased, etc. And that's what Brennan's pointing out here. The voir dire was necessarily insufficient and fruitless. So let's go to footnote 3. To this day, the correspondence between the defense and ARCCA witnesses is missing context. No discovery has been forthcoming since February 13, 2025. Notably, during the pendency of this case, this is the only time the defense produced reciprocal discovery prior to a discovery deadline. So first, Brennan's saying you have lots of examples of the defense not turning over reciprocal discovery, which is a huge problem. And then now you have Brennan saying, listen, there's evidence here that the material that we have so far, even from the U.S. Attorney's tip-off and between ARCCA and Read, isn't the full conversations here. Now, that's what I was going to talk about. Let's go back up a little bit here. I got, of course, an indication that news might have been breaking right as I read the most important sentence. Let's back up now that we have that context. Notably, the defense disclosures on February 13, 2025, came one day after the new administration at the U.S. Attorney's Office produced, in response to the Commonwealth's TUI request, materials that included correspondence between it and the defense. The implications of that are that the new U.S. Attorney's Office released a new TUI request to Hank Brennan that had material in it that tipped Brennan off to the fact that all this was going on. And then the very next day, either Brennan went to Jackson and was like, what's this? And Jackson was like, oh, we got to come clean. Or somebody at the U.S. Attorney's Office was like, we gave them a little bit. We're going to give them more unless you do it yourself. Either way, that sentence alone has monumental implications. A lot of this has big implications, but that's very direct. A lot of what we've been reading has not been as direct. That is extremely direct. And the way that it's direct indicates that this is all connected. That the documents given to Brennan were in the possession of the prior U.S. Attorney's Office, but not revealed. The new U.S. Attorney's Office revealed the documents to Brennan, indicating contacts and payment between ARCCA and the defense. That prompted the defense to have to reveal more documents. That's where we are today. Now, no one has, I think, really put all this together, because the implications of that are that we're looking at a modern black mass, and that you had the old DOJ looking the other way on what Karen Read had done as to John's death and what Turtle Boy was doing in some sense to torment people, because they were looking to get a bigger fish. It was a wink and a nod to Karen Read and maybe even Turtle Boy for a little bit, because they were trying to get the bigger fish, Michael Morrissey, in this MSP unit attached to the Norfolk DA. That's the underlying sort of tension that is very much playing out in real time here. And Hank Brennan's pointing it out in the most interesting way. You have to really, and I highlighted it on Twitter earlier, you have to really pay attention to the way Hank Brennan is framing the discussion here. What he's saying with the way in which that timeline played out. He's almost like dropping a very big hint that the new U.S. Attorney's Office issued a burn notice, basically, to Karen Read and Alan Jackson and forced all this information out into the public. That's huge. I don't think anyone, as I mentioned, I don't think people have really picked up on what the undercurrent there is. I mean, if you watch these streams, if you read my posts, I'm saying it. I think we're getting there. I think folks are starting to piece it together. But the implications are simply too momentous. All of the dominoes combining in that way are too momentous. And that's why people struggle to grasp it, because it's not just that this is extremely not okay, but it's the kind of generational misconduct that forces us to re-examine our relationship with the way in which we view the integrity of our systems of justice. That's the kind of games that Karen Read and her attorneys were playing. Needed that sip of water. And so we went through those next paragraphs, and we very clearly laid out what Karen and ARCCA were doing. But now let's get a little bit more about what happened on cross with ARCCA during the first trial that led Brennan to realize something was up. It is still unexplained why Dr. Rentschler disclosed for the first time in cross-examination that he learned of additional evidence that was favorable to the Commonwealth or inculpatory as to Read's guilt, so showing Read's guilt. Evidence that the victim was not wearing a jacket, the victim's DNA was located on the defendant's taillight, the victim's DNA was on a drinking glass near his body, and that microscopic pieces of taillight were recovered in the victim's clothes. So if you're wondering, during cross, all the evidence that the ARCCA experts just were not told by the DOJ or Read And to not be told that by the DOJ or Read can only mean it wasn't just collusion between the DOJ and Read. They were trying to force ARCCA, probably with ARCCA's help, to come to a specific conclusion that ran contrary to the evidence, and therefore ARCCA is biased, and therefore Read's motion should be denied, because not only should the jury not be able to hear that ARCCA was unbiased, the jury should hear ARCCA was biased. I love Hank Brennan. He does this all the time. He'll take your motion, he'll win, he'll be like, no, screw this person's motion. Let's flip it around. It's not that you should just deny the motion, Judge Cannoni, and prevent ARCCA from being presented as non-biased. We got to flip this around here. ARCCA is biased. And I got my own motion to call him biased. I love this man. We need to protect Hank Brennan. Even if he leads the invasion to liberate Europe from the rising BRICS threat, we can't actually send Hank Brennan to the European shores. We must protect him in the general headquarters, and he shall command the troops. We'll have a whole towel battalion. It'll be like the Ghost Army before the invasion of Normandy. We'll just set up a bunch of towels, make it look like we're staging an invasion up through Sweden or Norway or whatever the hell's up there, and then really we'll just go straight in through the beaches of Normandy. The BRICS will never see it coming. We're coming to save you, murdered by Maestro. If we need to liberate Europe, Hank Brennan's going to do it. Have no fear. I'm still waiting. Somebody sent me this message that was like, oh my God. And I was like, oh my God, something must have happened. And then they didn't follow up. So if something major has happened and you want to say it in chat about the Karen Read trial, please let me know. I haven't seen anything myself. Okay, you know what? Let's take a pause and read some comments, because if something did happen, I will break into the stream and tell you. The canon ARCCA used is actually a great representation of Karen Read's expert entire work. They use the right tool, but wrong application of tools. Same as Green. Yeah, Richard Green, I have gone in depth about how he misread a Celebrate read-ahead data point in the WallDB file so bad that Celebrate updated its GUI tools so that no one would ever make that mistake again. Jackson and United were caught with their pants down. As an allegory, yes. Intention to compensate. No, because murder by Maestro, when you're crossing someone, you can ask if they expect to be compensated in the future, even if they haven't been compensated now. It's a part of the Rule 14 provisions. Hank Brennan is brilliant. What are the possible reasons that the DOJ would get involved in a simple hit-and-run case? Oh, politics, because there was Rachel Rollins and Dustin Chow had grudges against Michael Morrissey for different reasons, and this was a great way to take it out. And also that old DOJ under Rollins and Levy really didn't like cops. Like, they were very, like, riding that, like, all cops are bastards movement. It's very strange to think of the DOJ embodying that, but I think that was playing a role too. The exact kind of power struggle Grant describes has just played out in public with the LA office regarding John Lewin. I wish I was more up to date on that. He'd make a great judge. Brennan would make a great judge. Seemed like this new DOJ isn't playing games. Agree? Grant, you'd be passing me by in Amsterdam. You'd never leave. Trust me. Oh, I've been to Gray Area. I actually saw Holland. I saw Robin's last game in 2017 when Holland played Sweden, and it was the final World Cup qualifier that year, and Holland needed to win by like 5 goals or something, and they only won 2-1. Anyway, I have been to Amsterdam a lot. It's a very nice place. My sibling actually lives somewhere in Holland right now. She married a very nice Dutch man. I don't speak Dutch, though, just a little Swedish. All right, back to the motion. Okay. So, we just talked about all of the pieces of ARCCA's report that were not, all of the pieces of evidence that were inculpatory to Read that ARCCA just didn't know about or didn't include on their report. And what's interesting is some of the emails that Brennan read out in the prior record between ARCCA and Read's lawyers. ARCCA was saying, the ARCCA expert, I think it was Wolf, was saying things like, oh, do you not want me to mention that during testimony, certain things? So it's like, did ARCCA get told all this and just say, oh yeah, we don't need to mention that, that's inconvenient for our conclusion? That would be a big problem. Dr. Rentschler alluded to the details of those findings and suggested that he had been provided the actual crime laboratory reports or information not publicly revealed from either the defense or from the U.S. Attorney's Office. Oh, Hank Brennan, how do you hide this stuff in plain sight? And also, how do you hide it in such a way where my brain foreshadows where you're going? I'm a little bit concerned, sir. Oh, my word. Do you all understand what this man just said? He said exactly what I was just saying to you, but in very, very circumspect language. He basically just accused ARCCA of having that information and intentionally ignoring it. That's explosive. Wow. So let's take a look at that footnote. See transcript 36, line 174. Quote, this is the ARCCA expert. I believe DNA was tested and some DNA was found. I believe a small amount. I don't believe any blood evidence was located or found on any pieces, but there was indication of DNA on the taillight housing. Notably, prior to Dr. Rentschler's testimony, the Commonwealth was not notified of additional material reviewed or considered by either ARCCA witness. Additionally, the defense has produced no reciprocal discovery about their communications with Dr. Rentschler. Yeah, he's just hammering them over and over and over because he wants ARCCA excluded as well. Just leave me hanging. You just send me a message. Oh my God. I'm like, what happened? You just leave me hanging. I'm like, what if the world is collapsing? Have the aliens invaded? Should I look outside? Oh, Mass Courts is down right now, so I can't tell you. Oh, maybe it'll come back up. Trying to figure out what's going on the Read docket and to try to give you all some update, but I can't get on Mass Courts. Hold on. We're going to get back to this motion. We're making our way through it. But also, I would like to point out that going back to this paragraph here, Hank Brennan hides stuff in plain sight so wonderfully. Even like I just said, Hank Brennan didn't say it there, but he basically came out and said that quote indicates that all of that information that I think it was D was pointing out in the YouTube comments earlier, all of that information and that Brennan reiterated there, the DNA evidence, what John was wearing, the state of Karen's taillight, the drinking glass, ARCCA may have actually known about all that DNA evidence and intentionally didn't include it in their report. And indeed, ARCCA made reference on cross to some of that material, but didn't include it in their materials reviewed, proffered in the report. And they don't even know how ARCCA got to review it. Wait a minute. Hank Brennan's making... This man thinks in puzzles and speaks in like layers. I think what he's saying there, he's implying that the defense gave ARCCA material outside of the scope of the federal government giving ARCCA material, and therefore it's further evidence of the defense violating the federal protective order and the defense doing this weird end run around where ARCCA had material they were claiming not to have reviewed so they could shape their conclusion a certain way. Damn, Hank Brennan. That's like 6 words. All he has to say is, it is unknown the source of these materials. That's the insight. But if you don't have everything before it, it just means nothing. That's brilliant. He's not like a literary writer. He is actually a genius. I'm worried about measuring this man's intellect. I think we're going to find that this man has a brain. I don't know. He probably does have like didactic. I don't know what it's called when you have instant recall, but he probably has that. And then he also has this ability to layer insights in a way that the reader can understand. His target reader, Judge Cannoni, can understand, but the public would never understand. It's like the opposite of Alan Jackson. He's like sending a message that when you have a really strong point, when the facts are really on your side, this isn't really as much of a legal argument, but when the facts are really on your side, you don't have to scream them from the rooftops. They're weighty enough. Just put them out there. People will figure it out. I don't necessarily know if that's going to work, but it's certainly a testament to Hank Brennan's style. I mean, work in terms of the public getting this. Maybe some people will be able to parse it out. But most people in reading this are not going to be able to pull most of this out. Maybe if they have a compendium or read some analysis before they start looking at it. But no, it's really hiding in plain sight. It's actually why I delayed doing this stream, because I wanted to bait people into trying to do it without the benefit of my analysis, to go back and compare it later to see how much they missed. I was starting to get frustrated with people just replicating what I was saying. I wanted to make them do the work a little bit. So let's see who fell into that trap. All right, next paragraph. It is disingenuous for the defense to posture the ARCCA witnesses as completely neutral and independent. Notice now we're back to the legal argument. Hank Brennan wasn't even making a legal argument. He was just dominating ARCCA and Read on the facts. He was just, in a very subtle way, dominating them. Since the February 18, 2025 hearing date, the Commonwealth has learned that the defense-ARCCA relationship appears cozier than once portrayed. This immediately made me be like, Jules! Footnote 5. Notably, photographs have recently been discovered by the Commonwealth and subsequently produced in discovery to the defense, Brennan means, depicting Dr. Rentschler attending a private luncheon and conversing with the defendant's father at this luncheon. First of all, a luncheon? Should I bring my luncheonette? Second of all, do you understand what that means? That means that beyond the documented contacts with ARCCA, now there's going to be evidence that ARCCA was commingling with the defense in ways they definitely shouldn't have been. Oh, Hank Brennan. But I said Jules because there's some CV Jules or someone on the Facebook groups who is very, very good at finding that kind of stuff, or either like open sourcing it from social media where it'll often get like posted because someone like took a video or took a picture in one of these luncheons and like shared it, cause, you know, like a FKR, Free Karen Read supporter, but then other people will analyze it and then that'll come back around. And anyway, so that I was just like, I can't wait to figure out how Hank Brennan was sent that, because everything that Hank Brennan gets sent, if he uses it, he has to send to the defense. So we're going to find out eventually how he figured out all this stuff. But yes, I love how he says appears cozier than once portrayed. He's being very gentle. Fourth, posturing that the ARCCA experts were retained by the U.S. Attorney's Office and introducing a federal investigation to the jury implies some speculation of wrongdoing attributed to investigators and or civilian witnesses. Introduction of a federal investigation would in turn demand a complete and transparent portrait. So this is what Brennan's saying. He's like, listen, you want to let Read even say the sentence that ARCCA was initially hired, mind you, only for $9,000, and then Read paid them $23,000 more. So if Read even wants to say, oh yeah, so ARCCA initially got paid by the government and then we paid them more, even to just say that, Brennan's like, all right, if that happens, then what we will need to do is we'll need to say that the introduction of the federal investigation to the jury is only balanced if the jury is fully informed about the actual relationship between the defense and the prior administration at the U.S. Attorney's Office. Ooh, dear God, that means the defense doesn't have a relationship with anyone at the current U.S. Attorney's Office. Impacted the scope and direction guiding the ARCCA investigation. Complete discovery revealing the entire relationship between ARCCA and the defense, and the conclusion that the United States Attorney's Office engaged in a comprehensive investigation and that its investigation is now closed. Also, the jury should be informed that the now closed federal investigation had no target, led to no indictments, no criminal complaints, no charges, and no other adverse finding, and instead impliedly absolved the witnesses of any wrongdoing. Which is very rare, because you'll never get if you're investigated and nothing happens, you don't get like a letter. I've actually seen that once or twice, but only to like members of Congress who demanded it after there was like a political threat of them being investigated and then they were cleared. I've seen like them get a letter saying you were investigated and we found nothing. But that's as close as you're ever going to get to being exonerated by the federal government. Them impaneling a very long process, and then no charges, no indictments, no targets, nothing. But Brennan goes on to say, because of the complexity of the defense request and the fact that information necessary to create a full picture is both missing and would lead to a trial within a trial, the Commonwealth objects to the defense motion and requests the motion be denied. So what Brennan's saying is that Read shouldn't be able to go down the route of even saying why ARCCA was paid initially, because it would force the Commonwealth to then engage in this tete-a-tete where they would have to, or tit-for-tat, where they would have to say, the state would have to say, ARCCA may have been paid initially by a federal probe, but that was pretextual. It was manipulated. It was the result of bad faith. Read then went on to pay ARCCA the difference after the federal probe was closed. The federal probe closed without any indictments or anything, no charges, no targets. It creates this trial. Brennan's saying there's this evidentiary standard that if introduction of this kind of evidence would create a trial within a trial of all the sub-issues related to the federal investigation, then introducing it this way should not happen. And I think Brennan's going to win his motion. I think we're going to get evidence of this other ways. I think we're going to get evidence of ARCCA's bias, but we're not going to get evidence of ARCCA's impartiality rebutted by evidence of ARCCA's bias. It's just, in fact, let me go further. ARCCA's going to be excluded from the witness list, in my opinion. Partially, I think Brennan's sending a message here like, Karen, you don't really want to call these people. Like, Brennan's moving to exclude them, but he's really saying, like, you're out of your mind to call these people. Okay, so I'm going to take, we're going to do two things. One, I'm going to read some questions, and then two, I have to pull up a email because I said to someone that I would try to meet with them about a project I'm working on. But there's no way that's going to happen because I'm not going to get finished with these other two motions in time. And while I'm doing that, I'm also going to bring up your comments, and I will try to answer some of those comments if any of them are relevant. And then also, of course, if you are enjoying this stream and you do want to help offset server costs, you, of course, can do that. The Cash App and the Venmo are on the screen. I don't accept super chats. I don't run ads or anything like that. It's just kind of user powered. Oh, okay, good. So 5 o'clock is good. Give me an extra hour. I don't accept super chats. I don't accept anything of that nature. I just accept your donations. And if you think this public information service is worth it, I'm thrilled. And I might have big news coming soon about a further expansion of my public information service. I don't even know how to put this. There's just some very exciting things that could be happening, and I'm excited to be involved in them. Let's see if we have any comments here. Oh, Cindy said, thank you for all your hard work and dedication. I appreciate you watching. Thank you, Cindy. Lynn says, hi, Grant. Hi, Lynn. Good to see you. Let's see. Trevor says, Karen's crimes are 5-year mandatory minimum sentences. If it's OUI manslaughter, 5 to 20. If it's manslaughter or something like that, 2.5 to 20. But there's a lot of discretion, and the prosecutor can, as part of the plea agreement, agree to a sentencing cap and then give Read a limited ability to appeal if sentencing ends up higher than that cap. Oh, yes, don't forget to hit the thumbs up button. I don't do a lot of YouTube streams because I mostly stream on Twitter where almost all the viewers are, but I'm thrilled to be on YouTube because it's much easier to read comments here, and if you leave a thumbs up or subscribe or whatnot, that's very helpful. I think Jackson and Unetti should face serious consequences for lying intentionally numerous times to the court. It doesn't get any more serious than that for attorney ethics. Yeah, I think they got exposed doing that too. I agree with you, D. Maui Swift asks, what are your thoughts on Karen actually getting convicted of murder too? If you look at the murder 2, reckless second-degree malice murder, if you look at the third prong, which doesn't require intent to kill but gets you intent by way of an underlying reckless act that a reasonable person knew or should have known caused a plain and strong likelihood of death, if you overlap that with involuntary or with OUI manslaughter or OUI motor vehicle homicide or manslaughter, that it is manslaughter. Like, for a lay jury, the ability to parse the difference between a recklessness mens rea, getting around an intent to kill under second-degree murder, when they also in their face have the same language saying that is a recklessness mens rea, although it might be negligence, but a recklessness mens rea leading into a situation where a reasonable person knew or should have known there was a strong or plain likelihood of death is OUI manslaughter, is manslaughter. And I think that makes it very hard for a jury to convict on murder too, because they're basically saying, how can this language from the lesser crime also be incorporated in murder too? Now, is the prosecution right in Massachusetts? The third prong under the intent requirement of malice second-degree murder does not require intent to kill, but instead a recklessness mens rea to do the underlying act in question, backing up a car while drunk in a way that a reasonable person knew or should have known could cause a plain or strong likelihood of death or serious injury. Yes, it fits within the statutory framework, but it's more appropriately understood by a jury as OUI manslaughter or something, or OUI motor vehicle homicide, or manslaughter. And that's why I think that's the most likely charge for a plea, or for her conviction. Now, what Karen wants to avoid is if she gets convicted, there's no upper bound on this sentence. Judge Cannoni can and will throw the book at her. There's a lot of aggravating factors. So during sentencing, there's mitigating factors like your character, your family support, whatever. Then there are aggravating factors like you doing bad things, you being inappropriate in court, all sorts of things. And Karen, if she gets convicted on even OUI manslaughter, OUI motor vehicle homicide, no upper bound on the sentencing, she could be looking at real hard time, even with an early parole or release. If she takes a plea, I think it'll come down to whether it will be OUI manslaughter or manslaughter. My opinion is Karen probably wants to avoid the OUI manslaughter, not because of the sentencing range, but because it comes with a mandatory lifetime license disqualification if you get OUI manslaughter. Maybe Karen takes a few more years on the upper bound under the manslaughter charge, but I don't know. The state's got to be willing to give her a license. And also, don't forget the wild card here, which is that if Karen has information that would result in Aidan Kearney being convicted, that makes it a lot different, folks, because then you do come down a little bit on the years. Maybe you do give her manslaughter or something like that, if she can guarantee a conviction for Aidan Kearney. Someone said, I think Karen intentionally hit John, but there is not enough proof to convince beyond reasonable doubt. No, I don't think you don't need that. You don't need proof of intent to hit or kill. What you need is proof that Karen, in the moment, while backing up the car, knew that it was so dangerous, or any reasonable person in that position would have known that the action of going to 24.5 miles an hour while drunk, while John was around the car, was so dangerous that there was a strong and plain likelihood of death. That, I think, the evidence proves beyond a reasonable doubt. No, it's not. You can't have a heat of passion. That's a very complex defense, and it's not it really only applies in a situation where, like, you shoot someone like out of reaction. And the other thing is, what's way more heat of passion is a very narrow defense, very, very narrow. In fact, it might not even be that common anymore, because what it is now is like temporary insanity. It tends to be more the argument, and that's a very hard thing to prove as well. Insanity defenses don't work for the most part, even temporary insanity defenses. Now, you want to know what's really fucked up? There used to be something called the gay panic defense. It's very it doesn't exist anymore now. I think it came out of like Texas in the 80s or something, where like if you were straight and a gay person tried to hit on you and you shot them, that was a defense to murder. Thank God that precedent went away, but that was the thing. That was the thing. All right, by the way, it's coming past 4 o'clock, folks, here, and I'm trying to check the docket for you, but Mass Courts is not. Yeah, you should look it up, Maui Swift. It's called the gay panic defense. It's not around anymore, but it was a thing in the 80s. in only a few states. It was not the majority rule. It never became like precedent, but some states observed a form of it. Karen wants to say she went home and fell asleep with John out there in the cold. She is screwed. I don't think there's any way. No, if she pleads, she's going to have to say that she didn't know whether or not she hit him, and it was irresponsible of her not to go back. There's no way she can just go say, yeah, there's no, oh, I might have read your comment wrong. Yeah, but also, if you are wondering, in just 3 hours, the part 1 of the Karen Read documentary will go up on ID Discovery. Definitely give that a watch. I think 7 p.m. Eastern or so it goes up, so keep an eye out for that. I don't think it's going to be very good for Karen. I'll have a review at some point this week, probably maybe at some point tomorrow. What is tomorrow? Tuesday? I might have actually a slightly busy day tomorrow. Oh, we have court tomorrow. Oh, goodness, I might have to watch from home. I was a little dizzy today. All right, we'll see what's oh, and then, of course, Aidan Kearney has court tomorrow, and who knows what's going to happen, whether he'll face a bail revocation. You know, I just as a pause here, so folks remember, so tomorrow we have dueling hearings. You have Aidan Kearney's hearing at 9 a.m. in Stoughton District Court related to the new charges he picked up for yelling into a pizza shop's video camera that was owned by a witness in the Karen Read trial. And that led to felony witness intimidation charges. Now, Kearney's bail conditions were already changed in the Superior Court in his existing felony witness intimidation and wiretapping cases. There's 18 or so charges in total, involving a number of witnesses in the Read trial, and then, of course, involving independent journalist Lindsay Catani, who herself was one of the first reporters to expose, because of her information through Aidan Kearney, that Karen Read and Josh Levy, the former U.S. attorney, were talking directly in the fall of 2023. Along with a bunch of other information. Of course, that culminated in the situation on the night of December 23rd, 2023, when Karen Read specifically told Aidan Kearney not to go over to Lindsay Catani's apartment. And then that situation, of course, led to Kearney's bail being revoked. But Aidan Kearney, that was back in December of 2023, Kearney's bail being revoked the first time. Now, what's very interesting is Kearney has said on a live stream at one point that he was approached and offered the ability to get out of jail during that bail revocation if he flipped on Karen Read. So I do think this sort of undercurrent of will Kearney flip on Read, will Read flip on Kearney regarding the underlying witness intimidation probes is very interesting. There are, of course, group text messages that were released over the course of 2024 that occurred in May of 2024, wherein Aidan Kearney strongly implies that it was Karen Read who asked Kearney to Google one of the witnesses in Read's own case, Jen McCabe, Google her license plates at a certain point during the pretrial process. And then also, not Google, run them, actually. Kearney is accused of asking a police dispatcher named Janelle Webb to run those license plates at Karen Read's request. And then there's also evidence that Kearney may have been asked by Karen Read to ask Jen McCabe questions. That would, of course, be problematic for Read because she has no contact orders, I think, with the witnesses in the case against her. And there's all sorts of dynamics there. But all of that is to say that Aidan Kearney's bail revocation, or it might not be a bail revocation hearing, but there's an arraignment on his new charges tomorrow at 9, and then the hearing for all of Karen's Read's motions and the state's motions in limine, although it could go 2 days, will start tomorrow. Now, at Kearney's hearing, the interesting question is, Kearney previously had his bail conditions amended in the Superior Court just a few weeks ago. I think it was on March 5th or so, maybe a little bit after that, after he picked up the new charges, to include no contact provisions, indirect or otherwise, with the witnesses in his named cases. But there's just been this weird series of events over this past week or so, where Kearney has kind of read comments on his YouTube streams that were directed at the people who he had no indirect or direct contact orders with. And he just said some things that were a little uncouth about Judge Cannoni and some of the witnesses. There was just there were some statements that really concern me personally, but what I think is irrelevant. But in the lead up to tomorrow, from what I understand, and I'm not a lawyer or you're a lawyer or anyone's lawyer, I'm a towel. But from what I understand, tomorrow Kearney could face a bail revocation because the only time bail, you can amend bail in other cases for picking up new charges, whatever. But the only time you can move to revoke bail is at the arraignment for the new charges, because you technically, the judge in the other cases can consider any act when changing bail conditions, the felony cases. But in this new, out of Superior Court, but in this new Stoughton District Court case, the only time you can move to revoke bail is at the initial arraignment, which is tomorrow. So we won't know, I don't think, until tomorrow morning whether we're going to see a move to revoke bail. Perhaps we'll find out some news, but that's something to keep in mind. And then at the same time, as I mentioned, the Karen Read hearing will start around 9 a.m. But the documentary, part 1, starts tonight at 7 p.m. Eastern, so about 2 hours and 50 minutes from now. But we're not done, because this was only the last motion today. I just read this first. Let's take some time to go through. We're not going to read them as in depth. I don't need to provide line-by-line commentary. But let's go through some of the other motions that the Commonwealth put up, and let's talk about those. And then let's read a few comments. Murder by Maestro says, it's almost like the state had a long plan, that the professionals who do this for a living have more insight than the random free Karen Read folks. Who would have thought it, huh? I agree. D says, if the gay panic defense applied to straight men, just about every woman in the world would press charges. Yes, I tend to agree. I think the only reason the gay panic defense existed was because, exactly, it didn't apply in the situation between straight men and straight women for that reason. It was very bigoted. And, yeah. I'm not entirely, Maui Swift says, I'm not entirely convinced they will revoke his bail. Well, bail revocation is a two-pronged consideration. It's one, did you pick up a new charge? So if he gets arraigned tomorrow, that's automatically the check of box 1. And then I think the second box, although I'm not a lawyer or you're a lawyer or anyone's lawyer, I'm just a towel and this is not legal advice. You should get a lawyer if you have questions about the law. The second thing with revoking bail is it's not so much about making him return to court or follow court orders. It's, is he a threat to the safety of a specific person or the community? So you have to look at the one that I think Kearney has talked about. He doesn't really know who the judge is tomorrow. I think the regular judge for Stoughton District Court is on vacation or something this week. So it's this judge that Kearney, I think, looked up for something, but he didn't really know. So that's a bit of a wild card. And then you got the situation with, this is the same exact charge that he, like, same exact charge, some of the same exact people that he's already facing out of the felony court, out of the under the felony charges out of Superior Court. That looks bad to the judge. And then it depends what Special Prosecutor Robert Cosgrove goes in there with tomorrow. If Special Prosecutor Cosgrove goes in there and has substantial evidence of Kearney flouting the new bail conditions or whatever, it's not a good sign. We could see potentially at least a motion. So that's going to be interesting. But again, Kearney is for folks just getting caught up. Kearney is on the witness list for the prosecution in Read's trial. And what I think Hank Brennan's doing is he's going to move under Lampron to get Kearney's phone records. The subject, they were already searched in November 2024, 2 of Kearney's phones in the context of his criminal cases. Brennan's going to move to get the phones. Then Brennan's going to call Aidan Kearney. And what Brennan's going to do is, before he calls Kearney, we're going to see another motion from Brennan under Mahoney for a consciousness of guilt instruction against Karen Read by way of witness intimidation. And the way that Brennan's going to demonstrate to the jury the evidence of the witness intimidation is through what's called a joint venture between Read and Kearney, which doesn't require Read to be charged with the underlying crime of witness intimidation. Just gets Brennan the ability to get in all the evidence through Kearney, from Kearney's phone, of Kearney and Read collaborating as to potentially tormenting witnesses. Once all of that evidence comes in, then Brennan can circle back again and then have the jury told before they go deliberate that all that evidence they saw come in through Kearney's testimony and the phone and Kearney's phone is evidence of Karen's consciousness of guilt. And one more really interesting component. We, those who've been following the Karen Read trial for a while, you're used to someone getting up on direct, whatever side they're called for, the prosecution or defense, and it's very friendly. Hello, how are you? What did you do next? What did you do after your report? And what did you do next? And when did you, and what happened then? And why did you do, etc. Very open-ended, broad questions. You don't lead the witness. You just let them tell their narrative and you interject with who, what, when, where, and why questions to break up the pacing. On cross, it's a little different, right? You said this in your report. Isn't that true? And you went here on Tuesday, June 12th. Isn't that true? And at that time, you did this. Isn't that right? And you would agree with me that a person's memory gets worse, not better, over time. Isn't that true? Always and yes or no question, however you want to phrase it. But it's not open-ended. Now, imagine the situation where you're Hank Brennan, and now you're calling Aidan Kearney to use as a witness against Karen Read. If you start saying to Kearney open-ended questions, he's immediately going to do something stupid and get classified as a hostile witness. And do you know what happens when Aidan Kearney becomes a hostile witness? Even if Hank Brennan calls Kearney on direct, Brennan doesn't just have to get up there and ask him questions that Kearney can just ramble on about. Brennan will be allowed to cross Kearney on direct. So you'd get this very strange Twilight Zone situation where Brennan calls Kearney, starts crossing Kearney about the contents of his phone, and then Brennan finishes, and then Judge Cannoni would say, okay, Alan Jackson or David Dianetti, do you want to cross Mr. Kearney now? And by the way, you might be saying, why is Hank Brennan doing this? Why would he, even if he thinks he can best Aidan Kearney, why would he do this? And the reasoning is simple. If you want to use Aidan Kearney's statements against Karen Read, you can technically make an argument under the 801 D2E, which is the co-conspirator exception to the hearsay rule. A hearsay statement is any out-of-court statement, okay? But there's an exception offered to prove the truth of the matter asserted. But there's an exception to the hearsay rule, so you can get in Kearney's statements just on their own, by way of a co-conspirator exception, which is 801 D2E to the hearsay rule. Statements by a co-conspirator are per se non-testimonial, so there's no confrontation clause issue, and then they come in under the exception because they're hearsay, but they're allowed in because they're co-conspirator statements, which can be established through a preponderance of the evidence by way of a joint venture. Very similar to the joint venture concept for establishing consciousness of guilt, but it has its own functionality within 801 D2E, which is the hearsay exception. Okay, but the point of that is to say, what you would do in that situation is you would call Brian Tully or something, and you would say, okay, what did Kearney's messages say? And then you'd have to argue the hearsay exception. Brennan was like, I'm not dealing with that shit. I'm just going to call Kearney himself, because then Kearney will authenticate his own messages. You remove the hearsay problem entirely. You want to know why? Because Karen Read gets to cross him. And what happens if Karen Read gets to cross Aidan Kearney? The statements aren't hearsay. I mean, they're Kearney statements that were made. They're still going to have to come in some sense, but Kearney is there. You can cross him. He's going to give testimonial evidence. It's genius. It's a layered, beautiful play. Now, how interesting it will be if Kearney's in jail and Brennan's got to get a writ of habeas to bring. By the way, you can do a habeas petition to the Supreme Court, but then also, if the court wants you as a prisoner brought to court to testify, they issue a habe. They tell the sheriff to bring your body to the court, and then you testify. I think you get to wear a suit, though. But if Kearney goes to jail, we could well see that. I really want this docket to load. I wonder if Mass Courts is down for me or everyone. Sometimes it just goes up and down. All right, it's back now. You really can't control state-run systems. You just have to kind of go along with what they do. And it would be like Judge Canoni to drop something like right at 4:30. That is her style. Same with Hank Brennan. Also, have you ever read a 700-item docket on your cell phone? It is exceptionally convoluted and unnecessary. The mass court system is great once you know how to use it. Oh, there we go. We got a new motion. Commonwealth's motion for buffer zone and order prohibiting signs and or clothing in favor of either party or law enforcement. Hold on. I caught it. So occasionally my mic will do that. And hold on. Is sound back? I'm back. I'm back. I'm back. I understand. I caught it very quickly this time. Hold on. I'm back. Yes. So sometimes what happens is when I move my microphone around, it switches to my other mic, which doesn't actually work. So we're back. I know, we're back. But listen, there's a lot of stuff going on. The buffer zone order just went up. If you missed it, what I was saying is the buffer zone order has gone up, but it looks like no signs or clothing in favor of either party or law enforcement. And it looks like that is going to, I don't know if it's going to apply within the buffer zone around the whole courthouse. We missed all the reaction to the new docket. Well, I mean, I basically said I think this is, it's going to be for signs or clothing in favor of either party. So I don't think they want those blue shirts out there. I told you all they didn't like it. I just sensed that it was a nice show of support, but it's not what the state wants. Like this dueling imagery, they just don't want any of it. It's a trial. Oh, and then I was saying, I don't know who's going to get us this document, whether it's Dee Dee or Christina Rex or who, but someone normally gets these documents pretty quickly. Weird that he put in there that police can... Wait, what? Hold on, I think someone has the document. It says something about police using force. I wonder if it was because they went hands on with me. I'm trying to get this document for us, folks. And what I was saying was there are 4 people who normally get these documents. Dee Dee, Dag Nabbit, myself, or Christina Rex. I'm waiting for this document right now, though, so hold tight. This is the buffer zone order that just went up for Karen Reed's retrial. It literally just hit the docket. However, it's not an order yet. It's a motion from the Commonwealth. However, Mass Courts, I think, is not exactly functioning very well today because I'm only able to access it from one device. So as soon as we get this motion, I will let you know. I'm monitoring for other changes to the docket as well. But the buffer zone order or motion going in, I mean, it was expected. It was from last time. But what the request is from the Commonwealth, remember last time I think the Commonwealth asked for 500 yards. Judge Cannone only granted 200 or 300. I could see it being way bigger this time. Maybe Brennan asked for 500. I could see Judge Cannone granting 500. All right. So I'm waiting. Hold on. I'm waiting. Let's see. Someone got it? Not yet. Hold on. I'm being told to stand by. Towel's on standby. So we are going to get this motion, folks. This is what you know. What I said earlier, I was like, I'm going to wait to do this stream for 2 reasons. One, I want to let people go out and do their own analysis so I can analyze whether they can do it on their own. And 2, I want to see if anything else hits the docket. And I was like, I'm not going to wait till 4:30. But alas, it was worth it. We went till 4:30, and something has hit the docket. Let's see if we got any questions, actually, because I will read some of these other motions, but now all you all are going to want to hear is this buffer zone motion. So until I get the buffer zone motion, that's all you're going to be thinking about. So we will ask some questions as the team docket rocket stars are doing their work, the little gremlin magicians that they are, trying to find this document. The reason why we all respect each other so much is there have literally been times when either like Dag Nabbit or whatever will be like, we need a document, and I will just drop everything and drive to the courthouse. Literally, I'll just drive there. So whether we agree on the case or not, there are those of us who put like a lot of effort into getting these documents. So when a new document comes up, it's always the same 4 people who go hunting for it. Now, I'm not going to take you all on a drive right now. I'm not Tom's CPU. I can't stream and drive at the same time. That even if I had someone coordinating this on the back end, I would not do that. Tommy probably uses a mount or something. He doesn't actually hold the camera, but I still couldn't do that. All right, what do we got? Anything? It's up. I got it. Thank you to... Wait, is that the whole... That's not the whole motion. That's not the whole motion? Is that the whole fucking motion? Wow. What's he want? He wants a 200-foot. Hold on, I'm getting you all the motion here. It's going to pop up on your screen in just 1 second. All right, and then ready? Watch the magic. There it is. It's a little bit too zoomed in, Grant. Yes, I know. All right, I got the motion. Someone corrected me earlier. It was actually my own mother. And she was like, Grant, when someone writes a response to a motion, it's not another motion, it's a memoranda. Well, actually, at first, I was like, there are memorandums. And then she was like, no, it's memoranda. All right, here we go. We got our buffer zone order. All right. Commonwealth's motion for buffer zone and order prohibiting signs or clothing in favor of either party or law enforcement. During the defendant's first trial, the court established a buffer zone. Oh, okay, wait a minute. I read this wrong. It's not 200. Let's see if he's asking for the same one. During the defendant's first trial, the court established a buffer zone in which demonstrations were prohibited within 200 feet of the courthouse complex. The Commonwealth requests that this buffer zone be reestablished for the defendant's upcoming trial, but with two important modifications. First, on the western side of the courthouse, facing Court Street. So what that means is when you walk out the front door of the courthouse and go to the left towards the traffic light, and so the courthouse is behind you, and you're walking towards Court Street. So imagine this: if you're walking out of the Superior Court, you take a left, okay? You walk straight on that sidewalk. The courthouse is now behind you on your left. That's what Brennan's talking about. Walking out the door to the left towards Court Street. The extent of the buffer zone was inadequate to prevent such demonstrations from jeopardizing the integrity and the fairness of the proceedings. The demonstrations could be heard inside the courthouse, including by the jurors during their deliberations. To prevent this from reoccurring, the Commonwealth's request that this buffer zone be extended to include the area encompassed within Bates Court, Bullard Street, and Ames Street, and Court Street. Okay, we're going to have to pull out a map. Murder by Maestro, we need a map. Second, the Commonwealth requests that the court's buffer zone order expressly include a mechanism for its enforcement. Where a person is believed to have violated the buffer zone provision and has refused to request to comply, law enforcement should be authorized to use reasonable physical force and to arrest the person to ensure compliance. All right, now hold on. We're gonna zoom a little further out. 1 second. Additionally, the Commonwealth requests that the court again order that individuals are not permitted to wear or exhibit any buttons, photographs, clothing, or insignia relating to the case or to any trial participant in the courthouse during the retrial. All right, so here's what we need to do. We're going to do this together, actually. We're going to go to Norfolk Superior Court. All right. Maps. All right. Now let's how big does he want? This is actually pretty complicated. So, is that 200 feet? Yep. All right. Let's go ahead and... Who is it? All right. Hold on. What do we got? Is this that breaking news you wanted to tell me about? Okay. Hold on. All right. So, now, if you're wondering what I'm doing, we are going to actually map out this buffer zone because I am intent on figuring out what this is going to look like. And the benefit is we will get to, together in real time, take a look, and hopefully that will be a useful resource, because what I'm seeing is this buffer zone is actually quite expansive, if it is what I think it is. So hold on. All right, I got the map, the good old map posted there. Now I gotta grab this map here, and then I gotta bring it up for you all on the screen. Okay, we're halfway there. And then I'm going to actually edit this map in real time, and we're going to draw the buffer zone. Okay, you ready for this? Watch this magic happen. Towel's a magician. Okay, now ready? We have to do one more thing. Hold on. Okay, now, Murder by Maestro, are you proud of me? Watch me do this. I'm going to grab a black line. Okay. Then, you know how we're going to figure out how big 200 feet is? We're going to use this handy dandy reference 200 feet. And that's exactly 200 feet. Perfect. So, are you sure it's 200 feet, Prosecutor Brennan? I think he might be right, but I thought it was 200 yards. No, it might actually be 200 feet. No, that doesn't make sense. I think he might be wrong about that. I think it was 200 yards, Prosecutor Brennan, because I'm pretty sure it started like right here. Yeah, it's 200 yards. He made a mistake. But needless to say, because it wouldn't be 200 feet, that's way too short. Hold on, we can double check this. Let's actually do the research. That's what you expect from me. So, all right. So let's go here, and let's go buffer zone. Okay. No, buffer zone from me, not about Turkmenistan. Okay, let me see. What do I got here? Trying to look for this buffer zone. I know I have it. It is 200 foot. Wait, really? All right, so hold on. I found my map of the buffer zone for the first trial, and it is 200 feet. So now let's take a look at the expanded proposed buffer zone. Hank Brennan wants to also include, so it's going to be 200 feet. So that black line is the kind of establishing area. And then Brennan also wants to include Bates Court, Bullard Street, Ames Street, and Court Street. Bates Court, Bullard, Ames, and Court. Bullard, Bates Court, where's Ames? Oh, there too? So you want what? Oh, I think he's suggesting that it actually go all the way out to there. Am I right about that? Do you all see where I have the... So I'm going to make it into a red dot so you can see it a little easier, but and then I'm going to increase the line thickness. But I think that's what Brennan's suggesting, that the buffer zone run all the way out, because let me just read it again. The buffer zone be extended to includes the areas encompassed within those 4. But, wait, so is it, hold on a second. No, I want them to be decoupled. I don't need them to be. Oh, that's incredibly frustrating. I don't need the 2 things to actually be attached. What is the outer boundary of this? Bates Court, Bullard, Ames, and Court. Oh, okay, so it's actually here. But it does, he's saying encompass that. So he wants the buffer zone to start here or 200 feet past there. Let's just say he wants it to start here, okay? Then that puts it all the way over there, okay? Let's change that to red. All right. I think I got this right. Okay. And then we're going to need a few more of these. So let's take one of them here. All right. And so it looks like he wants it out to here. No, because he said Bates Court, right? Yeah, so he actually wants it shrunk. He doesn't want it all the way out to there. That would be a little excessive. Oh, he wants the church in it. I wonder if he talked to the church. Okay, and then so the buffer zone would then, he wants it to include Ames Street too. So he wants it to go all the way over here? Okay. And then he wants it to come back down this way. So like that, and then it covers the, oh, no, get back over here. It already covers 200 feet past the Registry of Deeds, so 200, wait, but he wants Ames Street in it too, so he wants it like over here. Okay, and then it would come like about here. Okay, that seems about right. But then it only would go 200 feet on this side. Okay, so 200 feet. That's about 200 feet. Let's be precise though. And then it just would come like, is that 200 feet? Yeah, that's about 200 feet. Hold on, I'm going to have to do an actual 200 feet gradient measurement here. All right, let's go ahead and turn this thing. Where's the turn button? Oh, there's the turn button. All right, here we go. Is that about 200 feet? No, it's not 200 feet. So let's make that about 200 feet. It would be nice if that would stay 0, but okay. Okay, that's 200 feet. So now let's go ahead and bring that about 200 feet. Now let's see where that 200 feet is. Oh, so I was about right. Yeah, I nailed it. Okay, so now is that 200 feet? Let's spin it this way. Yeah, that's about 200 feet. Okay, so that gives us this. That's what I think Hank Brennan's proposing as the buffer zone. That's yeah, not bad. I think it's a good proposal. I think it covers what Brennan's trying to accomplish. All right, a few more things. Quickly, the Commonwealth's motion in limine to exclude the expert testimony of Garrett Wing. This is a motion to exclude Karen's purported dog bite expert because all the state has is a CV and nothing more, no expert report, no nothing. So without more, that expert's not testifying. Then you get the Commonwealth's motion to exclude one of Read's experts' opinion on the investigation itself. This ends up being a very long motion about how the defendant needs to actually meet 5 requirements for the expert to be able to testify. The testimony has to assist the trier of fact. The witness has to be qualified. The facts have to be sufficient to ensure the witness is able to give admissible opinion that's not mere speculation. The expert opinion has to be based on a reliable principle or methodology. And fifth, the expert opinion is reliably applied. The expert's opinion is reliably applied the principles and methods to the facts of the case. Now, this argument is going to be, I didn't read the whole thing, but this argument is basically going to be believed that this expert can offer some material, but some opinions on, I think, like cell phone location towers, but nothing on the actual quality of the investigation, which is really what Read wanted to call him on. And the motion by, oh, interesting. So let's actually take a read of this. The Commonwealth moves to exclude the proposed personal opinion of Michael Easter, a retired special agent of the FBI, regarding alleged inadequacies in the investigation. To the Commonwealth's knowledge, Mr. Easter was not involved in the U.S. Attorney's Office for the District of Massachusetts investigation into the death of John O'Keefe. Commonwealth v. Barbosa, cert denied. The Commonwealth does not dispute that Mr. Easter is qualified to render an opinion regarding cell site and cell tower location information. However, Mr. Easter is not qualified to render his opinion about any alleged inadequacies in the police investigation. That is a determination left solely to the trier of fact. The touchstone of admissibility is reliability, and the defendant must establish the 5 foundational requirements. We talked about those. While the defendant has the right to base her defense on the failure of police to adequately investigate a murder in order to raise the issue of reasonable doubt as to the defendant's guilt in the mind of the jury, this is achieved through cross-examination of the witnesses and not a different law enforcement officer to opine that he would have conducted the investigation differently. See Commonwealth v. Finney, 446 Mass 155, Penn site 165 through 166, 2006. Police reports detailing the incriminating words and conduct of another suspect would be admissible to show that the police were on notice the suspect but failed to investigate his possible involvement in the murder. A defendant does not have an unfettered right. So Brennan's saying there, you have to have something in the police's own documents. It can't just be some other police officer not involved who's opining on the quality of the investigation. A defendant does not have an unfettered right to elicit evidence regarding the adequacy of the police investigation. The admissibility of such evidence hinges first and foremost on its relevance. Commonwealth v. Moore. Relevant evidence means evidence having any tendency to make a consequential fact more or less probable and provide a link in the chain of proof. Mr. Easter's opinions are premised upon unspecified discovery material provided by the Commonwealth from an electronic folder produced to him by Attorney Jackson. The entirety of what he reviewed or did not review was not disclosed to the Commonwealth. Mr. Easter's opinions contrasting best practices are devoid of any real-world considerations, such as whether and without consideration of the physical evidence, the defendant's many statements, the vehicle data, the fact that the witnesses have testified under oath in many situations 3 times, and an understanding that it was a grand jury of citizens who charged and indicted the defendant. Further, that's quite an insult. Further, while qualified to render an opinion on CSLI location information, there is no inclination that Mr. Easter has the training and experience in investigating homicides, particularly in the first few critical days of an investigation. Notably, the conduct of a police officer that of a reasonable officer on the scene, acknowledging that the officer may be forced to make split-second judgments in certain difficult circumstances, prevent the courts from engaging in unrealistic second-guessing of police officers' decisions. In allegations of excessive force, expert witness testimony was irrelevant and unfairly prejudicial, where the fact that someone with the opportunity to prepare an expert report at leisure opines that well-trained officers would have performed differently under pressure. So basically saying you can't just be an expert who comes in and says this is not how an officer should have done it. Mr. Easter's report, you need to prove a non-thorough investigation through actual direct evidence, not somebody's opinion. Mr. Easter's report also seems to suggest that the defense is attempting to backdoor third-party culprit into a Bowden defense, while often confused with each other, third-party culprit and Bowden defenses are logically and legally different. Commonwealth v. Silva Santiago, Commonwealth v. Sin. Third-party culprit, he's like teaching here. Third-party culprit evidence is used to suggest that someone else committed the crime. So-called Bowden evidence is used to suggest that the evidence at trial may be inadequate or unreliable because the police failed to conduct the scientific test or to pursue leads that a reasonable police investigation would have conducted or investigated, and these tests or investigations reasonably may have led to significant evidence of the defendant's guilt or innocence. Evidence admitted pursuant to a Bowden defense is not hearsay because it is not offered to show the truth of the matter asserted. If the defendant intends to offer evidence that police knew of an alternative suspect and failed to take reasonable steps to investigate, the information may be admitted simply to show that information was provided to police and not adequately investigated. However, this does not mean that defense counsel may always be able to admit third-party culprits' evidence as part of a Bowden defense, even when it would otherwise not be admissible under third-party culprit defense. In contrast to the third-party culprit defense, where evidence may be admitted regardless of whether the police knew of the suspect, third-party culprit information is admissible under a Bowden defense only if the police had learned of it during the investigation and failed reasonably to act on the information. Furthermore, unlike third-party culprit evidence, there is no constitutional right to present a Bowden defense. The defense is speculative, so it seems like what Brennan's arguing is what they really want is to argue that, hey, someone else did it and the police didn't do a good job. But that's not how you argue that. You don't bring in this third-party police expert. You have to develop it under either this third-party culprit theory, which Reed's never going to be able to use, or this Bowden standard, which has nothing to do with this police officer's, this retired agent's opinion about anything. The Bowden factors have their own analysis unrelated to some person's opinion. The defense's speculative claims, bolstered only by unreliable innuendos or a difference of opinion that serves to critique 3 years after the fact, investigative steps taken by law enforcement do not rise to sufficient probative weight that exceeds the risk of unfair prejudice to the Commonwealth and would confuse the jury by diverting their attention to collateral matters. For the reasons stated above, Mr. Easter should be excluded from testifying about any perceived inadequacies in the investigation. Well done, Hank Brennan. And then we get back to the we got one more. And so this is the motion to exclude Jordan Wechsler, which is another expert for Reed, and then a request for voir dire. I thought I was almost done. Every time I think I'm out, they pull me back in. Now it's actually, I know what it is. This is the Commonwealth's opposition to Reed's request to exclude a state witness. And so this is the Commonwealth defending its expert. The Commonwealth, now comes the Commonwealth and respectfully requests that this honorable court deny the defendant's motion without a hearing. So basically just say this expert can testify. A witness may testify to a matter which they have personal knowledge. The witness must be competent. To be competent, the witness must have the general ability or capacity to observe, remember, and give expression to that which he or she has seen, heard, or experienced, in addition to an ability to tell the truth. When scientific, technical, or other specialized knowledge will assist a jury in understanding the evidence or determine a fact at issue, a witness qualified by knowledge, skill, experience, or training, or education may offer an opinion if his testimony is based upon sufficient facts or data, the testimony is the product of a reliable principle and methods, and the witness has applied those principles and methods reliably. Expert opinion is therefore divorced from the personal knowledge of a competent witness. In admitting expert testimony, the standards are set forth in Daubert. And the Daubert-Lanigan test looks at the general acceptance, whether theory could be tested, or whether there's been peer review or publication. Let's see. Now we're just setting up the Daubert standard. And then the Daubert standard addresses whether the underlying theory or process of the expert testimony is reliable. Similarly applicable to expert testimony based on technical or other specialized knowledge as it is to scientific testimony. This is all just setting up the standard. Expert testimony or on the scientific or specialized theory is needed if the subject or expert is beyond the common knowledge or understanding of the lay juror. Where there's sufficient evidence to find that the expert is qualified and that the testing procedures were performed reliably. Other challenges to the performance of testing go to the weight, not reliability. So they're saying, Brennan's saying, if the defense wants to challenge that kind of stuff, do it on cross. The evidence must be helpful. Should the witness be considered an expert? A Daubert hearing is unnecessary to permit his testimony. A judge can allow an expert to testify without a Daubert hearing. A Daubert hearing is generally not required where courts have previously admitted expert testimony of the same type, where the testimony is offered for the same purpose, and where there is no factual issue as to whether the expert is qualified, whether the appropriate methodology has been followed, or whether the quality of evidence is sufficient to permit an opinion. The testing performed by Dr. Welchler is widely utilized. Dr. Welchler is certainly qualified and would testify to the methodology employed during his analysis. Despite the defendant's assertions to the contrary and a seemingly endless echo chamber of disinformation, the Commonwealth produced to the defendant not only a copy of Dr. Wechsler's detailed report regarding his opinion, but also the extensive list of material he reviewed in formulating said opinion. Copies of those materials reviewed, 352 pages, a copy of his PowerPoint presentation related to those materials and his report, a link to download the raw microSD card of those materials, and a link to the entirety of Dr. Wechsler's case file. See Notice of Discovery 57, items 6, 7, 8, 9, 13, and Notice of Discovery 58, items number 13 to 14. Furthermore, Dr. Wechsler's report lists over the first 7.5 pages the specific material he reviewed in coming to his opinions. The report further enumerates 11 items of additional information obtained by Dr. Wechsler to assist in his analysis. Dr. Wechsler's narrative section of his report details within the body of the report where in the 140-slide PowerPoint presentation he elucidates with demonstrative evidence to support his opinions, in direct contrast to the defendant's characterizations of the doctor's report as virtually unintelligible. Ooh, Hank Brennan's snarky. In addition, the portion of Dr. Wechsler's presentation of which the defendant seemingly most prominently complains, the paint testing, does not solely include a mix of images as the defendant suggests. The presentation includes photographic memorialization of the testing in question, but also slides with video memorialization of the testing and its outcome, which clearly and unequivocally support Dr. Wechsler's opinion that the location and orientation of the lacerations on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right taillight of the Read 2021 Lexus LX 570. So there you go. That's pretty specific, and it's not unintelligible. Notably, the defense does not challenge Dr. Wechsler's qualifications to offer biomechanical expert opinion testimony and concedes that a biomechanical engineer is qualified to testify as to the general principles of biomechanics. Hank Brennan is so snarky. Rather, the defense challenges only whether Dr. Wechsler is qualified to testify to medical causation of the injuries, an opinion he has not proffered. So he's not even offering that. Biomechanics are qualified to determine what injury causation forces are in general, can tell how a hypothetical person's body will respond to these forces, but are not qualified to render medical opinions regarding the precise cause of a specific injury. Dr. Wechsler's biomechanical engineering opinions involve the application of classic engineering mechanics theory. He provides biomechanical causation analysis, which employs objective biomechanical data and analysis to determine whether the forces resulting from particular events are consistent with the sustained pathological conditions or a clinically diagnosed symptom. Or, in this particular case, the biomechanical causation of the lacerations on the victim's forearm being consistent with the 2021 Lexus LX 570 taillight and the biomechanical causation of a 2021 Lexus LX 570 striking the victim and the victim's head hitting the ground. There's Hank Brennan's theory of the case. C. Wagner v. Schlumberger Tech Corp. Expert in biomechanics may testify to matters in their respective areas of expertise, including the forces involved in the low-speed accident and how those forces may affect an individual or object. Expert may not express any opinions regarding whether victim suffered a brain injury or the cause of the alleged brain injury. Dr. Wechsler is very clear in his extensive report as to what types of analysis, opinions, and the basis for said opinion are. He states, as a biomechanical engineer, I have no opinion on any aspect of Mr. O'Keefe's medical treatment or medical diagnosis. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Dr. Wechsler then and throughout the body of his report makes specific reference to 2 pages of specifically enumerated references within his field of expertise that he has reviewed in arriving at his opinions. Situated between the classic disciplines of engineering and medicine, biomechanics provides a means of applying engineering mechanics to theory to a problem of accidental injury. Injury causation analysis is a multidisciplinary endeavor that employs objective mechanical and biomechanical data and analysis to determine whether a motor vehicle crash caused a pathological condition symptom diagnosed clinically. Dr. Wechsler never, within his report, analysis, and ultimate opinions, concedes the bounds of his discipline. His credentials and expertise exceeds the bounds of his discipline. His credentials and expertise within the field are profound and extensive. The defendant has been appropriately noticed of Dr. Wechsler's expertise, his opinions, and the extensive material he reviewed in formulating said opinions. Dr. Wechsler's methodology, detailed profusely within both his report and associated PowerPoint presentation, photographs, and videos, is well founded in his discipline, and his expertise within this discipline is unassailable. Dr. Wechsler's qualifications in the field of crash reconstruction and biomechanical engineering are beyond reproach. Dr. Wechsler's testimony should not be misconstrued as a medical opinion. That misses the point and exaggerates the extent to which the witness would be testifying to observations within his area of expertise. The Commonwealth has demonstrated that Dr. Wechsler's testimony and opinions are amply based on reliable biomechanical methods in testing that is generally accepted within the relevant scientific community, and will assist the jury in this case. Therefore, no hearing of voir dire is necessary, and Dr. Wechsler should be permitted to render his expert opinion in biomechanics. So yes, if Read's argument is a biomechanicist does not give medical advice, she's going to lose this motion, because a biomechanicist does, if that's the term, does not give medical advice. And he's not trying to give medical advice. There we go. We all got through. James Grant got through the motions and limit pocket for you. Closed while I was technically oh no, I was muted that. Oh no. I'm so sorry. I don't know when we lost sound. Let's see. When did it happen? I'm so sorry about that. Oh no. I can't believe that happened again. I'm sorry. I don't know how much you missed. I know that I was supposed to be keeping an eye on that microphone thing because it's been causing issues. But needless to say, I was just actually reading one of the last motions on the docket. So even if you weren't listening to my commentary, all I basically explained after we went over the buffer zone stuff was we talked a little bit about the Michael Easter's opinion being excluded because it goes beyond his ability to talk about the cell data, and then he starts trying to introduce a third-party defense by critiquing the investigation. And then we read through this motion regarding the Commonwealth defending its expert, who clearly has the ability to offer a biomechanical opinion. And Read's entire objection is that the expert was apparently, Read thought the expert was going to offer a medical opinion. And then Brennan cites case laws showing biomechanics are not medical opinions, and biomechanics can be offered by an expert, especially if they don't opine on medical conditions. And this has to do with the biomechanics expert for the Commonwealth pointing out that John O'Keefe's injuries are consistent with being struck in a sideswipe collision by a Lexus of the type owned by Karen Read and then falling to the ground and hitting his head. So I really am sorry that the sound went out. That has to do... Oh, you only missed a minute or so. So it's strangely, it's when I move around to look at the docket on my phone, I sometimes hit the microphone cord and it goes out. I'm going to try to either get a new cord or fix this, but I'm just going to be very cognizant of it when I'm looking at my stream in the future until I get a new microphone cord. But that said, you didn't miss that much. I was just closing out the analysis of that last motion. I am glad that you stayed with me on this stream. Murder by Maestro and Maui Swift and AK Lady, thank you for joining. And Nancy from the 508, thank you for letting me know about the no sound earlier. I appreciate those of you who joined on YouTube. I don't do many streams here, but I'm building it up. Definitely give a like and subscribe. We'll see if the channel can grow. I definitely get like a lot more viewers on Twitter, but the interaction there, the comments don't stay up on the screen as much. So if you want to ask me questions on future streams, try to pop over to the YouTube, where I have a wonderful moderator now. Thank you to Maui Swift. And then I also have it's a lot easier for me, turns out, to read the comments when they stay up on the screen. There must be some crazy stuff going on heading into tomorrow with the Aidan Kearney hearing at around 9 a.m. in Stoughton District Court. The Karen Read motions and limine hearings will start up at 9 a.m. big days for you folks tomorrow and the next day. Get ready for a lot of motions in limine to be ruled on. Get your docket papers ready. It's going to be hard to follow unless you have all the motions kind of at the ready with their docket numbers. I'll be with you to break it all down once we get rulings and after we see all the oral arguments. Especially, I think I'll be with you after about 12:30 or 1 tomorrow. I have some stuff in the morning, some doctors-related stuff, and then I actually have the dentist again. But anyway, I've been trying not to think about that. Thanks for being with me. I appreciate it. You know how to support the stream if you've been here, if you like this content, if you want to support this public information service. It keeps going because of you wonderful folks. My name's Grant Smith Ellis. Thanks for helping me fix the sound issues. Enjoy the rest of your afternoon. I'll try to keep you updated if anything more breaks over the next few hours. But until the next time we see each other, have a good, Monday, folks, and I'll see you very soon.